Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
Please receive the court is in session. 22117 Commonwealth versus Karen Reed.
All right, so I was told counsel wanted to see me.
Good morning, Your Honor. Yes,
Good morning.
we just have one brief issue we want to raise for the court.
Okay.
We wanted to confirm whether experts in this case are permitted to watch testimony in order to prepare for rebuttal. We'd asked for that
For rebuttal, like post,
responding,
for responding, okay,
in our case in chief, for both sides.
okay. What's your position? Ms. Little, you want to?
Yes, we could.
All right. Mr. Brennan, is there any reason not to?
I need to give it some thought. I'm not willing to agree. I'll abide by whatever the court thinks is fair.
So why don't you think about it? We'll address it later today. Okay, there's no expert testimony today, right?
It's not.
Okay.
Thank you.
All right, sure. Is that it? Ready to bring the jury in?
That's all.
You wanted a ruling on the clip from yesterday?
I did.
All right, you can play it.
Thank you.
All right, so we'll take a quick break.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Canoni, the Justice of the Superior Court, now holding in Dedham, within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
22117, the Commonwealth versus Karen Reed.
All right, good morning again, counsel. Good morning, Ms. Reed. Good morning, jurors. I have to ask you those same three questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we were here yesterday? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday? No. Everyone said no or should be. Thank you very much. Can we bring Mr. Whitley back in, please? Ms. Tianetti, you can step up to the podium.
Thank you very much, Your Honor. Sir, I'll remind you, you're still under oath. Thank you.
May I proceed?
Yes.
Mr. Whitley, yesterday you testified that when Karen Reed was brought to the hospital, she didn't want to get into a hospital Johnny and she didn't want to give a urine sample. Do you recall that testimony?
I do.
It was clear to you that her reluctance to cooperate at that time was because she very much wanted to check on John's progress and status at the hospital, correct?
No, I don't believe that to be the case.
Well, you testified before the grand jury regarding this matter 3 years ago, didn't you?
I don't believe I said that she was
I
reluctant.
didn't ask you that question. You testified before the grand jury 3 years ago, didn't you?
I testified before the grand jury 3 years ago.
You were under oath then, as you're under oath today, correct?
Correct.
You swore to tell the truth.
I am telling the truth.
You swore to tell the truth in 2022 before the grand jury, did you not?
I did.
That was less than 3 months after you brought Karen Reed to the hospital, didn't you?
Yeah.
And your memory of what happened at the hospital was very good in April of 2022, right?
As good as today?
Your memory in April of 2022 was very good, wasn't it?
It was very good as it is today.
Okay, so you want to add the as it is today, despite the fact that you weren't asked that question. Is that right?
Objection.
Sustained.
All right. When questioned by Mr. Lally at the grand jury, you were asked the following question. So what, if any, interaction did you have with her, meaning Ms. Reed, at the hospital once you were there? You remember that question, right?
I do.
And your answer was, after that, I helped escort her down to, they call it the psych hallway, where they have rooms set up for psychiatric patients for their evaluation. And then she was unhappy that she wasn't able to see him, meaning John. And she kept trying to. She didn't want to get into a hospital Johnny. She didn't want to, I believe, give a urine sample. She was not, the nurses were asking her to do certain things that every patient has to do, and she was not cooperating with them. Do you remember that answer?
I do.
So 3 years ago, when you testified about this issue of giving a urine sample, you testified under oath that you believed that she didn't want to give a urine sample, correct?
Correct.
Yesterday, 3 years later, you testified with certainty that she didn't want to give them, right?
Yeah, she was giving them a hard time about having to give a urine sample.
Right. No, I'm asking you about your testimony yesterday in contrast to the grand jury, sir.
Okay.
To the extent that I ask yes or no question, I'd like yes or no answers.
So
okay?
no instructions to the witness, Ms. Giannetti.
You
Ask a
the witness be
question.
instructed to answer the question yes or no if it calls for a yes or no question.
So
Answer.
Answer the question that's asked of you, okay?
Okay.
So go ahead, ask a question.
You testified yesterday that she didn't want to give a urine sample without saying it was your belief that she didn't want to give one, correct?
Correct.
In any case, were you aware that when she was asked to give a urine sample, that Ms. Reed had gotten her period and did not have a tampon?
I was aware she was on her period, yes.
You're also aware that when somebody is brought to the hospital for a Section 12, they have no privacy. Isn't that right?
They have medical privacy. Either the tech or the nurse would be with the patient at all times.
Okay. With them at all times, observing them at all times, correct?
So they wouldn't be, she wasn't in like a hallway open to the public.
Understood, sir, but she also, when I said privacy, what I was asking is, she was not allowed to go to the bathroom alone to give a urine sample, correct?
She was a psychiatric patient.
Right. So she would have to use the bathroom in front of hospital personnel or some medical personnel with people watching her while she was on her period with no tampon, correct?
I would understand that to be true.
All right. And you're aware that she did cooperate and eventually give a blood sample as well, correct?
I'm not aware of a blood sample, but urine sample, yes.
She did give the urine sample.
Correct.
All right. Now, in your testimony yesterday...
Of what Karen Reed may have asked you about John surviving in the snow with light clothing. You remember those questions?
John surviving in the snow with light clothing. You remember those questions?
I remember asking about not having a jacket, correct?
Now, starting at the end of the day, when I cross-examined you yesterday, I asked you about that topic, and I said to you, you mentioned something about hypothermia, that you assumed you may have been dealing with a hypothermia situation, and your answer was, well, she said that he had been out in the snow without a jacket for many hours, correct?
Correct.
But before I cross-examined you at the end of the day yesterday, you previously testified 3 times about this topic, correct?
I believe it would be the grand jury and the previous trial.
Right, and direct examination when Mr. Brennan was asking you questions before I stood up, correct?
Okay, yes.
Let's start with the first time you testified about this topic back in 2022. That was, again, less than 3 months after you had a conversation with Ms. Reed at the scene on January 29th, correct?
Correct.
Her statements and questions to you at the scene were fresh in your mind in April of 2022, correct?
Correct.
In April of 2022, before the grand jury, Mr. Lally asked you, quote, what if any questions did she ask you regarding hypothermia? Do you remember that question?
I do.
Your answer was, she was just wondering if he could have survived outside in the cold even though he didn't have a jacket on. Do you remember giving that answer?
I do.
Nowhere in that answer, in 2022, less than 3 months after these events, do you attribute the words, quote, many hours, end quote, in the snow to Ms. Reed, correct?
Yes, I was not.
I'm not asking for an explanation, sir. I'm asking for an answer.
All right, so he was answering you, Mr.
My
Unit.
question calls for a yes or no answer. Nowhere in your answer in 2022 do you attribute the words many hours in the snow to Ms. Reed, yes or no?
No, I did not say that at that point.
Nowhere in your answer in 2022 do you testify that Ms. Reed told you he had actually been in the snow for many hours, correct?
She did at that.
Sir, I'm asking you about your testimony.
I object.
So let him answer the question.
Let me ask it again. Nowhere in your answer in 2022 did you testify that Ms. Reed told you he had actually been in the snow for many hours, correct?
In 2022, I testified that I was just told to be brief and give generalizations. She quantified many hours in the snow when we were back at the
Let me try this again,
So,
sir.
Mr. Yannetti, you're just saying 2022. Get to a date
Of course,
and a
yes.
place.
April of 2022, okay, before the grand jury. My question again, and I'm still seeking a yes or no answer from you, okay? Nowhere in your answer in April of 2022, before the grand jury, did you testify under oath that Ms. Reed told you that John had actually been in the snow for many hours, correct?
Not in 2022 of April, no.
Okay. The next time you testified under oath was last year in 2024, correct?
Correct.
During that testimony, Mr. Lally asked you, oh, by the way, so 2022 is no mention of many hours, right?
I did not, and I was told to be brief on the grand jury stand.
But again, no mention of
Correct.
many hours in 2022. Okay. Now, 2024, last year, Mr. Lally asked you, so firefighter Whitley, at some point, specific to your conversations with the defendant, Ms. Reed, can you describe sort of her demeanor or any observations you made in relation to that as you were speaking with her? And your answer was, yes. She was very upset. She kept asking if there was any chance. She kept asking us if we knew if the person ambulance 1 had transported was alive or dead, and we could not speak to that. She asked if somebody could be alive in the snow without a jacket for many hours, correct?
Correct.
So 2022, there was no mention of many hours. 2024, over time, now that's the first time that you mention the words many hours in your testimony regarding this case, correct?
Correct.
All right. And when you testified last year, you testified still that she was asking you a question about surviving in the snow, correct?
Correct.
So then we come to yesterday on direct examination. Do you recall that Mr. Brennan yesterday asked you, before you left, were you having any conversations with the defendant, and you answered yes? You recall that yesterday?
Is that at the hospital?
I'm asking you yesterday, do you recall Mr. Brennan asking you, before you left essentially the scene, were you having any conversations with the defendant, and your answer was yes?
You're talking about Lee, I'm just trying to make sure we're talking about the same instance. Are we talking about when we left the hospital or when we left Fairview Road?
When you were at Fairview Road, leaving Fairview Road. We're talking about the same subject of what Ms. Reed supposedly told you or asked you. Okay? Mr. Brennan went into that with you.
So on the way to, you're talking on the way to the hospital in terms of left, when we left.
Well, before you left. He meant before you left the scene.
Okay, no, I'm just trying to clarify.
Again, the same conversation, Mr. Whitley. I'm not trying to trick you.
Mr. Yannetti, he just asked for a point of reference. It's clear. Now go.
Understood. And Mr. Brennan said, can you share with the jury what those conversations were about? And your answer was, so we were talking, she was upset. She kept asking if there was any chance her husband could be alive, even sitting outside in the snow without any coat for many hours. Do you recall that answer that you gave yesterday on direct examination?
Yes.
And that was the first time that you mentioned that she said, supposedly, or asked supposedly, about him sitting outside in the snow, correct?
I was just using phrases generally speaking. I wasn't at that point I was paraphrasing. I was not speaking verbatim to what she said.
Let's try that again. That was the first time that you mentioned that she claimed or asked that he was sitting outside, correct?
It could have been sitting, laying, being.
Let's try it a third time.
So just ask the question, not let's try it.
Sure.
Let's try it.
Was that the first time that you testified under oath that Ms. Reed said or asked about him sitting outside?
Are you asking me to clarify whether she used the word sitting?
I'm not asking you to clarify anything. I'm asking you whether that was the first time yesterday during direct examination that you mentioned that she asked about him sitting outside.
I'm sorry, I am very confused because I'm trying to figure out if he was being outside, sitting outside.
I'm asking you about Ms. Reed's statements, sir. That's all I've been asking you about. Her statements to you and your testimony about her statements to you. Was yesterday on direct examination the first time that you testified under oath that Ms. Reed mentioned the words sitting outside?
I don't know.
All right.
I'm just using, she might have said laying outside, being outside, outside.
Okay, so when you testified yesterday before this jury
Yes,
that she mentioned the words sitting outside, you're now saying that that might not have been accurate, correct?
it could have been a different word.
Okay, but you didn't say it could have been a different word yesterday, you just left it as sitting outside, correct?
Yeah, that's
Okay.
what I said, sitting.
All right, so now we get from, the grand jury with many hours mentioned, to questions about many hours, to sitting outside, to let's talk about what you said on cross-examination.
I object.
Okay, the objection sustained.
Sure. On cross-examination, your words were, she said he had been out in the snow without a jacket on for many hours, correct?
She had asked if he had been outside, if there was any chance he could be alive, even though he was outside without a jacket for many hours.
So it always was a question, correct?
It was a question.
She never said what you said on cross-examination yesterday, which was she said that he had been out in the snow without a jacket on for many hours. That was not a declarative statement by Ms. Reed, correct?
Objection.
I'll allow that. Was that a declarative statement by Ms. Reed?
She asked if he could be alive without a jacket in the snow for many hours.
So again, it was a question, sir.
She asked me, and we were just trying to give her hope in terms of telling stories of hypothermic patients that could survive outside in the snow.
Okay, is there any redirect?
Briefly.
Okay.
Thank you.
When you were called to the grand jury, was the testimony as in-depth and as long as it is in front of this jury?
No, not even close.
When you're recounting your memories of what happened, do you memorize word for word what you've said in the past?
Objection.
As to that form, it's sustained.
When you're recounting the past, do you record your statements personally?
Objection.
I'm going to let that one. Do you record your statements?
No.
Next question.
When you testified in the grand jury, page 90, line 15, and you said the defendant told you, I'm upset if he dies, I want to die. And then you later testify last year, and you said, if my husband dies, I want to die. Do you notice the little differences between those phrases?
I do.
Is that you making up words?
No.
Is that you trying to help a case?
Objection.
As to form, that's sustained.
Are you inventing facts?
No.
Sir, when you were recounting what happened that day, are you using your best memory?
Objection.
Sustained.
When you were asked by the defendant, about how long, or someone out in the snow without a jacket for many hours, do you remember that conversation with her?
I do.
Where were you during that conversation?
We were in the back of the ambulance.
Do you remember it distinctly?
I remember it distinctly. She was looking at me.
When you tried to give her hope and comfort, and you told her stories about other situations where people, maybe children, have fallen through the ice and had hypothermia, did you have that conversation with her in trying to comfort her?
I did.
Do you remember that conversation?
I do.
Did you necessarily share those conversations with the grand jury?
I don't recall if I did or I didn't.
Did you ever write that in your report?
No.
Is that something you typically put everything in your report?
No, we do not write. But generally, we only write patient complaint, what happened, and what they did, not their opinions or anything like that to what's going on.
Do you have any interest in the outcome of this case?
I do not.
How long have you been a firefighter for?
Since March of 2006, and an EMT since November of 2002.
Over 20 years.
Correct.
You said that you live near Kerry Roberts?
I do.
You've been to a block party for the kids where you've brought the fire engine down?
I do.
I'm going to allow it.
When you're at that block party, do you ever step out and have secret meetings with Kerry Roberts trying to corroborate some conspiracy on their behalf?
No.
I'm going to allow that.
No.
Put your career on the line?
Sister.
No further questions.
Any follow-up, Mr. Yannetti?
No, Your Honor.
All right, Firefighter Whitley, you are all set, sir.
Like to play clip 5, Your Honor?
And his mother leans over the kitchen island and says to me, I think it looks like you got hit by a car. It looks like you got hit by a car.
All right, who's your next witness, Mr. Brennan?
Next witness is Gene Demulus.
Okay.
Thank you.
You're welcome. Oh, thank you.
You solemnly swear the evidence given to the court and jury in the case now hearing to the truth, the whole truth, and nothing but the truth, so help you God. Yes, you take a seat.
Good morning.
Can you just scooch in close to the microphone? Thanks.
May I proceed?
Yes.
Good morning.
Good morning.
Could you please introduce yourself to the jury?
My name is Jean Demulus. I am the general manager at CF McCarthy's in Canton.
I'm going to ask you to keep your voice up, if you would, please.
Sure.
Thank you.
You said you're the general manager at CF McCarthy's?
In Canton, yes.
Thank you. How long have you been the general manager at CF McCarthy's in Canton for?
For 6 years.
Can you briefly describe for the jury what CF McCarthy's is?
It is a restaurant and bar.
At CF McCarthy's, is there a video surveillance system inside?
Yes.
Who owns that video surveillance system?
CF McCarthy's.
Are you familiar with the video system?
Yes.
Have you ever looked at it before?
Yes.
Do you employ people to help the establishment with the video system?
No.
You maintain it on your own?
Yes.
At some point were you visited by somebody from the Massachusetts State Police?
Yes.
Were you asked whether or not they could view some of your video surveillance?
Yes.
Do you remember the date? Not the date they came to visit you, the date that they were looking for.
I believe it was January 28th, 27th, 28th of 2022.
Around that time?
Yes.
Did you allow access to the video system?
Yes.
Did you oversee that access to the video system?
Yes.
Was it a state police officer?
It was two state police detectives.
Do you remember their names?
I remember one of the detectives' names. I do not remember the other detective.
The one you remember, could you share the name?
It was Detective Buchnick, Yuri.
Detective Yuri Buchnick.
Yes.
At some point, was he allowed to download information from the surveillance system?
Yes.
Did you watch him do that?
Yes, I did.
At some point, have you been able to briefly look at some of that download?
Yes.
And does it appear to be a fair and accurate depiction of the surveillance or the area of your bar?
Yes.
Move to introduce.
Okay, there's no objection, Ms. Giannetti?
There is no objection, Your Honor.
Exhibit 18, so marked.
Thank you.
Your Honor, may I play just a small portion?
Sure.
Thank you. Ma'am, I'm going to show you just some random shots from this video, but I want to know if you recognize it. Is this the inside of C.F. McCarthy's?
Yes.
I'm not asking if you have any particular knowledge or information about that night.
Looks like-
I want to know
Yes.
Is this a fair and accurate depiction of what C.F. McCarthy's looks like?
Yes.
Has there been any substantive, significant changes to the inside of that establishment
No.
since this video was taken?
No.
Okay. Thank you, Ms. Gilman. Your Honor, I have no further questions.
Okay.
I have no questions.
All right.
Thank you very much. Thank you.
Stepping down.
No, that comes.
Your next witness, Mr. Brennan.
Thank you. Bridget Miham.
Good morning.
May I proceed?
Yes.
Good morning.
Good morning.
Could you introduce yourself to the jury, please?
My name is Bridget Meehan.
Where do you work?
I work at the Waterfall Bar and Grill in Canton.
The name maybe tells us a little bit about it, but could you just share a couple lines of what the Waterfall Bar and Grill is?
It's a small family-owned business in Canton. It's in a mixed condo complex.
Are you involved in the ownership of it?
Yes.
How long have you been involved with the Waterfall Bar and Grill?
We've been there approximately 10 years.
Do you help run the establishment?
Yes, I do.
And you were running the establishment back on January 28, 2022? At some point, were you asked or visited to see if your establishment had video surveillance of the inside?
I was.
Does your establishment have video surveillance of the inside?
It does.
Do you have a camera and a server?
Do I have? Yes, I do.
Okay. Did you provide video surveillance to the Massachusetts State Police from that night, January 28, 2022?
Yes.
May I approach, Your Honor?
Yes.
I'd like to move this in as an exhibit, please.
Okay. Ms. Giannetti?
No objection.
Thank you.
Exhibit 22.
With the court's permission?
Yes.
Thank you. Ma'am, I'm going to show you just a brief clip. Okay, stop, please. Do you see that video?
I do.
Does that depict the inside of McCarthy's?
No.
I'm sorry, the waterfall?
Yes.
I'm trying to switch establishments on you. Back on January 28, 2022, does that look the way it looked then?
Yes.
Has there been any significant changes inside since then?
No.
Thank you. I have no further questions.
Okay.
No questions.
All right, Ms. Meehan, you
Thank you.
And I'll just that coming down.
Camerano.
All right, your next witness, Mr. Brennan.
Commonwealth calls Mike Camerano.
You solemnly swear the evidence given before the jury in the case will be the truth, the whole truth, and nothing but the truth, so help you God.
Good morning.
May I?
Please.
Good morning, sir.
Good morning.
Could you please introduce yourself to the jury?
Hi, good morning. My name is Michael Camerano.
Mr. Camerano, can I ask how old you are? I'm sorry.
Spell your last name.
Camerano.
And so if you could either move the microphone down a little bit or speak up, or maybe a combination of both, please.
Okay.
Thank you.
Thank you. Could I ask you how old you are?
48,
Where do you live?
Canton, Mass.
How long have you lived in Canton for?
Me and my wife have lived there for 20 years. Me and my wife have lived there for 20 years. We have 2 children.
How old are your children, sir?
My daughter is 17. My son is 14.
Did you know John O'Keefe?
Yes.
How did you know him?
I met John for the first time at his sister's, they had a benefit for his sister in 2013. I met John there for the first time. And then years later, our kids got involved with sports together, and they became very close. As they became close, I became very close with John and his family.
Was your daughter close with John's niece?
Yes.
Was your son close with?
Yes.
Did you spend a lot of time together through sports and socially?
Yes, we did.
I want to take you forward to January 28th of 2022.
Okay.
Do you remember that day?
Yes.
Had you, without any discussion of what might have been said, did you have any discussions with John that day?
Yes.
Did you have a plan?
Yes, we were communicating.
At some point, did you decide that you were going to spend some time or go meet John?
Yes. That Friday, my daughter and his daughter, they got acceptance letters to school. So we wanted to get them together so they could enjoy the time together. And, just, go over like how it'll be so much fun, something new and different. Yeah, so we were going to meet up after I got out of work.
Was your daughter planning to go to a new school?
Yes.
Where?
Bishop Fan.
And how about his niece?
Same.
They both got accepted to the same school?
They both got accepted to the same school.
Was it a celebratory move?
Yes.
Did you have a plan to bring the children together so they could celebrate?
Yes, we did.
And then separately you were going to meet John and celebrate?
Correct.
Okay. Where did you drop your daughter off?
I dropped my daughter off at John. I went into John's. I was at the house with John and the girls, and we had a little celebration. Talked about how nice it's going to be, fun, change, different, meet new people.
And you celebrated at John's house before you went out?
Correct.
After the celebration with your children, did you and John leave?
Yes.
During that celebration, was there anybody there other than you, John, and your 2 daughters?
No. No. Karen was not there.
Was there anybody else there?
No, just the 2 girls, myself and John.
What was the weather like that night?
It was cold. It was not snowing yet.
Was there an expectation for
Yes,
the
there's
next
an
morning?
expectation. Yes,
And what was that?
that there was going to be a big snowstorm coming in.
A storm was coming.
Yes.
When you left, did you leave in a separate car than John, or did you leave together?
No, we left together. We were John got in my car, and we were leaving. We're going to leave.
Where were the girls?
The girls are in the house, stayed in the house.
They were staying at John's house?
Yes, correct.
Where did you go?
We went to C.F. McCarthy's.
When you got there, did you know anybody who was there other than you and John?
At that time, no.
Did you spend time at C.F. McCarthy's?
Yes.
Were you drinking?
Yes.
Was John drinking?
Yes.
Alcohol?
Yes.
How long were you there for?
A couple hours.
While you were there, did anybody come and meet you that you knew?
Yes.
Who?
A friend, and then Karen came in.
The friend?
Yes.
What was the friend's name?
Kurt.
And then, how long after you first got there was it that the defendant arrived?
I would like to say within an hour, so not 100% sure.
You said back home it was a celebratory mood. Was it still a celebratory mood at McCarthy's?
Yes.
When the defendant arrived, did she spend time with you and John?
I've talked briefly to her, and her and John were mostly talking.
Okay. You didn't see any issues?
No.
Okay. It was a normal night?
Seemed to be, yes.
As far as you could see?
Yes.
And you saw John drinking?
Yes.
Did you see the defendant drinking?
I saw her with a glass, yes.
Okay. Did you leave at the same time that John left?
No, I did not.
When you left, was John still at the establishment?
Yes.
When you left, was the defendant still with him?
Yes.
Why did you leave?
I left because I got a phone call. My son was playing hockey in a backyard, and he got hit with a stick and lost his tooth.
Oh. Where did you go?
I went to my son's friend's house.
Do you know about what time that was when you went to see your son?
I would like to say 9:30, in between 9:30 and 10.
You didn't go back to McCarthy's that night, did you?
No, I did not.
After you helped your son, where did you go next?
I went to pick up my daughter, Madeline.
Did you go
at John's house?
Did you go in John's house?
No, I did not.
When you got to John's house, did your daughter come out?
No. We went to the side door
Okay.
and rang the doorbell.
And then what happened?
And then my daughter came to the door.
Where'd you go?
From there, we left and went home.
When you went home, had the weather changed at all?
It was cool. It might have been flurrying at that time.
No accumulation?
No.
You got home?
Yes.
Did you do anything significant when you got home?
Put the kids to bed, my son, and no, I went to bed.
What's the next thing you remember happening?
Waking up to, I missed some phone calls.
Who were the missed phone calls from?
From my wife and Karen.
What did you do?
I called my wife.
After speaking to your wife, what did you do?
I got in my car and drove to John's house.
About what time was this?
In between maybe 5 and 6 a.m.
Okay. What was your mood at that point?
I was panicked.
Why did you go to John's house?
Because I went to get Kaylee.
Did you know if she was alone?
Yes.
How long did it take you to get to John's house?
Maybe 5-7 minutes.
When you get to John's house, what do you see?
I pull in the driveway. I see that the garage door is open. I go in through the garage door. I don't know if Kaylee was standing there, if the door, she came out the door, and I asked her, if she needed anything, she could get in my car and stay warm.
When you first saw Kaylee, what did she look like?
She looked distraught.
Did you try to help her?
Well, I think I just said everything will be okay.
Did Did she come with you?
Yes.
Where are you going?
To my house.
So what happens?
So we go to my house, and my daughter's up, and the two girls are they were hanging downstairs, just hanging out, just being kids. And then, I don't know, a couple hours later, maybe, Paul called me and asked me to bring Kaylee home.
Did you know anything at that point?
I did, yes.
You did or didn't?
At that point, I did when Paul had told me.
So what do you do?
Ask Madeline and Kaylee if I'd say, Madeline, we come for the ride. I don't say anything to Kaylee, and we get in the car, and I start heading back to John's house.
And you didn't say anything to Kaylee?
No, I didn't. I just said everything will be all right. She had a feeling.
Why do you say that?
She don't want to go home.
So what happens next?
So I pull in the driveway, and I remember Paul and Papa standing. I think they were standing at the side door, and we just embraced.
Did you stay?
No, not long. No.
Did you go back?
I was to the house. I went back to my house.
Did you go back to John's house?
I did the next day. Yes, I was there.
When you went back, were there people there?
Yes.
Many?
There was people coming and going.
Thank you. I have no further questions.
Thank you. Good morning, Mr. Camerano.
Good morning.
This is quite painful for you to remember the events of January 28th, is it not?
Yes.
You were very close with your friend John O'Keefe, correct?
I was close with them, yes.
And you actually met Karen Reed through John, correct?
Correct.
After meeting Karen, you spent a good amount of time with both Karen and John, correct?
Correct.
As of January 28th of 2022, you had known Karen for maybe about a year or so?
Sounds correct.
And you'd see them especially on Fridays, correct?
Correct.
That would be sort of the day that you get together with both of them often?
Yes.
And of course, your children spent a lot of time with John and Karen, right?
Correct.
You entrusted both Karen and John with your kids.
Yes.
Sometimes your kids would even go on vacation with Karen and John, right?
They did go to the Cape, yes.
Sometimes you'd see Karen without John at your house or on a ball field.
Correct.
And your daughter in particular would sometimes spend time with just Karen without John, correct?
Correct.
Your daughter would sometimes go over to Karen's house in Mansfield when she lived there, correct?
Correct.
And obviously when your daughter would go to Karen's house in Mansfield, Karen would be the one in charge of caring for her, correct?
Correct.
And you were fine with that because you liked and you trusted Karen, right?
Correct.
And in your view, Karen was very good with kids, right?
Correct.
But you also had the opportunity to see Karen and John together, right?
Yes.
You saw how they interacted with each other over that year period that you knew Karen?
Yes.
You saw how they got along?
Yes.
And you never observed any arguments or bickering, correct?
I mean, they argued and bickered.
You had previously testified that you wouldn't even call it arguing, you'd just call it banter, right?
Yes, I mean, he would, he would get upset or like over if she bought expensive things for the kids,
Right.
yes.
Yeah,
Yes.
we will get to that. That would be the one thing that John would complain about, Karen buying like very nice things for his niece and nephew, right?
Correct.
Or he'd complain if, Karen was taking his niece and other girls to get their nails done, like extravagances like that.
Correct.
And one specific memory you have is when Karen bought his niece a very expensive sweater, right?
Correct.
And you recall John telling you that he wished that she hadn't done that because he considered that to be spoiling the girl, correct?
Yes.
But it was very clear to you from your observations that Karen really, really liked John. I'm sorry, John really, really liked Karen, right?
Sustained.
He certainly never told you or even suggested he was thinking about or planning to break up with Karen, right?
No.
Okay, so with regard to that Friday night, January 28th, sir, the plan was for you and John to go to McCarthy's to have some drinks because there was a storm coming in, correct? And because of the celebration of the girls getting into Bishop Fen?
Well, yeah, we were going out. It wasn't a continuation of the celebration of the girls. We were going out to have a few beers as guys.
Okay. And when you were leaving the house, John asked you to move your car, right?
Correct.
Where was your car when John asked you to move it that night?
Actually, I backed up my car. We were leaving the driveway, and John asked me to stop so he could move his car.
I see. And he wanted you to move your car because of the storm coming in, and you wanted Karen to be able to pull her car into the garage, right?
Correct.
And that was really thoughtful of him, wasn't it?
Yes, extremely.
And it showed you that he was being chivalrous toward Karen that night, right?
Yes.
He didn't want Karen to be out in the heavy snow later when she returned to his house during the expected blizzard, right?
Sustained.
You took from that there was an expectation that Karen would be coming back to his house, correct?
Objection.
Sustained.
You had no inkling that day that anything was wrong between Karen and John, correct?
No.
Everything seemed fine between the two of them, right?
Yes, he did mention though that night that he didn't understand why Karen had a plumber go to the house.
Because he had somebody that could have done that work instead of paying for the plumber, right?
Well, yes.
Okay. But in any case, the plan was for Karen to meet up with the two of you, right?
Yes.
And she did show up to McCarthy's at about 8:30 p.m. or so?
Yes, I guess, if that's the time.
And you saw an affection...
I'm sorry, what was the answer that you said?
If that was the time, I'm not sure about the timeline.
Okay. It was sometime after you'd gotten there. Right.
Correct.
But you do remember when Karen arrived, there was an affectionate greeting between John and Karen, right?
Yes.
You saw them kiss, right?
Yes.
You saw John put his arm around Karen?
Correct.
And you saw that Karen sort of nestled into his embrace?
Correct.
And when she did that, that's when he kissed her, correct?
Yes.
And they seemed happy to see each other, did they not?
They did.
That night they were affectionate?
Yes.
Laughing?
Yes.
Happy?
Yes.
Like a normal couple?
Yes.
No arguments?
No.
You witnessed no bickering, no tension, correct?
No.
And during the month before John's passing, that January of 2022, you observed their relationship in your presence to be normal, caring, and affectionate, right?
Yes.
Thank you very much, sir.
You were asked a number of questions about the relationship between John and Karen that night. Do you know what was going on behind closed doors other than what you saw?
Objection.
I'll allow it.
No.
Do you know whether or not they texted each other that day?
No, that day, no.
Do you know whether or not there was any arguments that day?
Objection.
I'll allow it.
Not to my, no, I don't know if they were, well, I don't know if they were arguing over the plumber situation. I
Do you
don't
know
know.
if there's any vulgarities that day?
No,
Do you know if there's any vulgarities that night?
no, not to my knowledge.
Do you know whether or not John was trying to end the relationship with Miss Reed?
Objection.
Do you know that, sir?
No,
Next question.
Do you know if there was any jealousy in that relationship?
Objection.
I'll allow it.
I mean, I mean, Karen wouldn't let, I mean, they did everything together, a lot of things together, and I thought at times, yeah, you could see, you know, she didn't want other women around John. I don't know, not at that, but.
Thank you.
Any follow-up?
Nothing further.
All right, Mr. Camerano, you're all set, sir.
So I'll just get them down, please.
I'll see counsel at sidebar for just a minute, please.
Two hours later.
Party, party up. Bottle, bring the cup. Pour it, pour it, pour it up. In your red solo cup. Red solo cup. Red, party up. Party, red solo cup. Red solo cup.
Keep these cups filled, I don't wanna see the bottom.
to throwing money round like I won the fucking lotto. 4 locals down, Red Bull.
May I?
Please.
I'm going to recall Nick Garino.
Okay.
Parliament, please.
Sure, you can have a seat. I'll remind you you're still in your room.
Or stand, however you're most comfortable today. Just do whatever you need to do, okay?
Thank you, Your Honor. Good morning, everyone.
Sir, yesterday we talked about downloading phones and making what you called extractions.
Yes.
And from that data, you could create different types of reports.
So have Detective Garino say his name again, please.
I'm sorry. Again, for the record, could you introduce yourself to the jury and spell your last name for the record?
Yeah. Good morning. My name is Nicholas Garino, Guarino.
Thank you.
Sir, you mentioned yesterday that you downloaded a number of phones, or you were involved in the process of downloading a number of phones.
That's correct.
You explained to us that after you have the data analyzed, you can pinpoint certain items that you may want to put in a document.
Yes, so the extractions into a program of our choosing, Cellbrite is the most commonly used, and then we can take call logs or text messages, any information that the investigator is looking for.
When you downloaded Mr. O'Keefe's phone and you downloaded the defendant's phone, did you try to create, or did you create a report through Cellbrite, the software, that would show you all of Mr. O'Keefe's call logs?
Yes, I did.
And when I use the term call logs, what does that mean?
The call logs are the calls that the phone receives.
How do you create a report from Cellbrite? Can you just walk us through that process briefly?
Yep, so in the program, you can go in and select the calls from it and export it into different formats, PDF, XML, HTML, or you can create a portable case and extract them all as a portable case that we would see on my computer.
May I approach, Your Honor?
Yes.
Showing you a document of Mr. O'Keefe's call logs. Do you recognize that?
Yes.
And what is it?
It is the call logs. Just want to make sure it's between John O'Keefe and the defendant from, just want to see the dates, the 28th, January 28th, 2022 to January 29th, 2022.
Would this contain all the phone calls from his phone data, the calls between those two parties that night?
Yes, that's what I created.
Thank you. I'd like to move this as an exhibit, please.
Okay. So,
If I could, Your Honor, just want to compare to make sure we got the same.
okay.
Thank you, Mr. Brennan.
Thank you, Mr. Brown. Content? Thank you, Your Honor. Content.
Okay.
No objection. You captured all of the phone calls between two parties on that last document. Can you also do that with chats?
Yes, that is true.
And did you do that in this case?
Yes, I did.
Did you create a document of chats between the phones of the defendant and Mr. O'Keefe for after midnight, for the evening hours of January 29, 2002?
Yes, I did.
May I approach?
Yes.
I'm good. You recognize that document, sir?
Yes, I do.
And can you tell us what that is?
These are the texts from the defendant to John O'Keefe. Yes.
For January 29, 2022?
Yes, that's correct. So I'm sorry.
Thank you. I move this as an exhibit, Your Honor.
Okay.
No objection, Your Honor.
Thank you.
624.
Did you identify or specify chat messages between John O'Keefe and a person named Jen McCabe?
Yes, I did.
Did you create a Cellbrite report?
Yes, I did.
May I approach?
Yes.
Can we have just a brief moment, please?
It's sidebar?
No.
Just the two of them?
Compare to what we have.
Yes, go ahead.
Thank you, Your Honor.
Okay.
Thank you, Mr. Wright. You're welcome. Sir, I'm handing you a document. Do you recognize it?
Yes. This is the text messages between John O'Keefe and Jen McCabe on January 29th, 2022.
And this is through a search of Cellbrite. You match their data, pull up all of their conversations.
Yes, that's correct. Yes.
Okay. I move to introduce this, please, Your Honor. No objection, Your Honor.
25.
Similarly to the chats, did you do the same with calls between Mr. O'Keefe and Ms. McCabe?
Yes, I did.
May I approach, Your Honor?
Yes.
Showing you a document, sir. Do you recognize that document?
Yes, this is the call log between John O'Keefe and Jen McCabe for, just want to make sure I have all the dates correct, just for January 29th, 2022.
Good evidence, Your Honor.
Okay.
No objection, Your Honor.
Exhibit 26.
Did you do a file extraction and a report on all chats between the phones of John O'Keefe and the defendant for a period of time?
Yes, I did.
May I approach, Your Honor?
Yes.
Handing you a document. Do you recognize that document? Handing you a document.
Yes, this is the text messages between. Yes, this is the text messages between John O'Keefe and the defendant from January 28th to January 29th, 2022.
Thank you. Your Honor, move this into evidence.
Okay. Mr. Alessi?
No objection, Your Honor.
All right, thank you.
Exhibit 27.
Did you have an opportunity to make a report from some of the data from the defendant's phone from January 29, 2022?
What are you referring? I did make some reports from the defendant's phone.
What's a call log report?
Again, the call log report is the calls that the party makes to another phone. So it's going to show everyone they've called or attempted to call.
May I approach, Your Honor?
Yes.
So I'm going to ask you to take a look at this document. Do you recognize it?
Yes.
And could you tell the jury what it is?
It's the call log from the defendant's phone for January 29th, 2022.
Thank you.
It looks like everyone she called.
Introduce this as an exhibit, please.
No objection, Your Honor.
Thank you.
Exhibit 28.
What we just introduced into evidence is the entire call log of calls to anybody and everybody to and from for that period of time.
Yes.
That's fair to say?
Yes, that's correct.
And then can you further isolate calls between just two parties?
Yes, you can. You can search by phone number or name.
And did you do that with the defendant's records for some parties?
Yes, I did.
Did you isolate phone calls between the defendant and Ms. McCabe for the evening of January 29, 2022?
Yes, I did.
May I approach?
Yes.
Let's take a look at this document. Do you recognize it?
Yes, I do.
What is it?
It's the phone calls from the defendant and Jennifer McCabe, January 29, 2022.
Thank you. Your Honor, I'd like to move this into evidence, please.
No objection, Your Honor.
All right, thank you.
Exhibit 29.
Did you isolate calls between the defendant and Ms. Roberts for the night of January 29, 22?
Yes, I did.
Can I see the last exhibit, please? Thank you, sir. I asked you to take a look at that document. Do you recognize it?
Yes, I do.
Could you share with the jury what it is?
Yep. It's the call logs between the defendant and Kerry Roberts for January 29th, 2022. Yes.
And that's a report you created?
Yes, it is.
Your Honor, listen to evidence, please.
No objection, Your Honor.
Okay, thank you.
Exhibit 30.
Did you have an opportunity to isolate and produce a report for all chats between the defendant and Ms. Roberts for the night of January 29, 2022?
Yes, I did.
May I approach, Your Honor?
Yes.
So I'm handing you a document. Do you recognize that?
Yes.
And could you share with the jury what that is?
This is text messages between the defendant and Kerry Roberts on January 29th, 2022.
Thank you. I would move this to evidence, please.
No objection, Your Honor.
Okay. Jurors, this is the way we have to put evidence in cases in Massachusetts, okay?
Exhibit 31.
Sir, do you have an opportunity to identify a text message or a chat between the defendant and a person by the name of Ingrid on the morning of January 29th, 2022?
Yes, I did.
May I approach?
Yes.
Take a look at this document. Do you recognize it?
Yes.
Could you tell the jury what that is?
Yes, this is a text conversation between the defendant and looks like a group chat between Ingrid Curtis and Bill Curtis.
Did you make that report?
Yes, and this is on January 29, 2022.
Thank you. And move this to evidence, please.
No objection, Your Honor.
Thank you.
Exhibit 32.
If this is a good time, if the honor would permit.
Okay. Jurors, what we're going to do is we will take our morning recess now, and we'll take 20 minutes to a half an hour, and we'll see you then.
Chris Fabricant is the person who knows more about bite mark evidence, also called forensic odontology, probably in the world. All right, he's written a great book called Junk Science. You can get it on all sorts of any place, Amazon, wherever you look it up. We put it, I think we put it on our website, on our little YouTube streaming site. And also, he does know that the setup to this was that the prosecution wanted to do dental molds on a German Shepherd who has aged several years, to show that even if these marks on the decedents in the hands, in this case, arms and hands, in this case, were from a German Shepherd, that they can tell through dog forensic odontology that this German Shepherd is specifically excluded by measurement. So I just want to have Chris Fabricant, give him a big welcome. He's going to be professorial, and he's going to talk to you about forensic odontology generally and why it's junk science. Now, you can differentiate a dog bite from a something else, from a whack or whatever, but that's not what we're talking here. Welcome, Chris.
Hey, Chris.
Thanks for having me. Yeah, it's all hogwash, and I'm not convinced that you could differentiate between a dog bite and some other bite. So even at that threshold level.
That's really interesting on it. But tell us about forensic odontology. You have, in your work with the Innocence Project, you have obviously are responsible for getting a lot of people out of prison who have actually gotten the death penalty for bite mark evidence. You and also my friend who's now a judge, Chris Ford in San Diego, was one of the forefront leaders in this. But you really have been the leader in taking it to the courts. Where does it stand? And why would a prosecutor, knowing all this, try to use dog forensic odontology in these days?
Prosecutors will, introduce whatever the judges and the courts will allow, and sadly, forensic odontology is still allowed by many, many courts around the country. With that said, though, last summer, Justice Sotomayor said in a published opinion, and a concurring opinion in one of my cases, Charles McQuarrie out of Alabama, that, this evidence has been entirely discredited, and I have 3 clients on death row right now, all put there through bite mark evidence. And there have been nearly 40 wrongful convictions and indictments attributable to the use of, so-called bite mark evidence. And really what you think about is that, trying to interpret an injury on skin, particularly in a homicide case, is that what the forensic dentist or the forensic pathologist or whomever it is that's going to come in and take a look at this evidence is going to do it long after these injuries were inflicted. So skin is an ever-changing medium, right? If somebody who's matches one day, might not match the next day, hour to hour, day to day, week to week, they're just capturing a moment in time that's going to be constantly changing. And you don't know the way that the arm was held when it was actually inflicted. So you think about it like the dog bit, or a person bit when the injury was like this, and then you take the photograph when your arm is extended, it's going to look completely different. So this is always just kind of gross speculation. And having competing experts in this type of case is just like 2 people arguing about how flat the earth is.
Wow. It seems to be that they must have had absolutely no DNA from a bite, because that would be so much easier and better.
I mean, even the forensic dentists will tell you, even the last of the Mohicans that are still holding on to this last shreds of this totally discredited technique will tell you, all of them will tell you, number one, swab it for DNA evidence, right? Because DNA evidence is a real science, unlike the voodoo of forensic odontology. So I have been getting a lot of emails about the Karen Reed trial because they're like, hey, Fabricant, do you know that they're trying to bring this in this trial and it's a dog bite evidence? And then I looked at it and I was like, that they literally took a dentition of a dog where there's no database, what the evidence shows, right? The forensic dentists who actually look at this stuff and day after day, week after week, they cannot reliably diagnose an injury as a bite mark, period, right? To say nothing of associating with anybody. So the idea that some expert could say that, oh, this was made by these teeth or that teeth is crazy, because you can't even say that what instrument was actually used to create the injury.
Interesting, because the judge did say to the prosecution, you do have an uphill road to get the fact that these teeth are specific to Chloe, the German Shepherd, in this case. That's just, can you, so talk to us about the fact about the specificity where anyone's trying to get specific to a specific, where you may be able to say it's dog bite, but specific through measurements of forensic odontology.
Again, I don't think that you could even say definitively that it's a dog bite. You know what I mean? They, you know, what you had, like they did a Daubert hearing in this case, right? And if you think about what's required for a Daubert hearing, right? One is testability, right? Somebody claims that that's a dog bite. How are we supposed to falsify that? We have no idea. We're just going to have to take your word for it. Okay, well, let's take your word for it. You're supposed to have an error rate, right? So how often do you get it right? And how often do you get it wrong when you claim something is a dog bite as compared to something else? No idea, right? So it's not a testable hypothesis. We don't know what error rates are. There is no peer-reviewed literature, not any real literature. There are some people that have written a little bit about this. It's totally rejected by the scientific community, and it's not maintained by any standards whatsoever, right? So it flunks every single one of the Daubert tests. So I was shocked that it was going to be let in at all.
Oh, yeah. Yeah. And we're not even factoring in dogs who have an Invisalign and they correct their bite over time. So
Right.
what about, you know, I'm sure in all of your experience studying, reporting on, analyzing dog bites, the victim always stands perfectly still so that the dog can make the best impression on the wound, right?
Right. You know, this is the point that I was making earlier, you know, I mean, is that, you know, bites of any kind from be it dog or human is inflicted almost always during a violent struggle where, you know, I mean, I think a lot of your viewers, you know, may be thinking that they have an idea of what a bite mark looks like in their mind because they have toddlers that come home from daycare and say, Johnny bit me, right? And it looks like a bite, right? But that's never the way they look in casework. It looks like in this Karen Reed case. You know, you could say like one person saying it's from a car, you know, another saying from a dog. Who's to say who's right? You know, I mean, without DNA evidence, you know, it's all speculation. There's no expert witness testimony that is going to advance this idea, right? Because the search for the truth is never advanced through junk science.
Right, right. As a matter of fact, as one of our mods points out, though, there was no Daubert hearing for Dr. Crosby, that's the Commonwealth expert, who took the dog bite impressions, and you know, and he's not even a forensic dentist. I mean, let's even get to that level. He's like somebody who trains dogs, a former police officer trains dogs, and
you know, what is it about somebody that's a dentist, though, really, or a dog trainer, that would have any expertise on interpreting an injury on skin? None, zero. What is the proximity to teeth? The proximity to dogs? It's crazy. You're just claiming this expertise because it's like, I'm near dogs. I know what dogs look like. I've seen a lot of dog bites. That's nonsense. It's the same kind of expertise that dentists were claiming. And it was just like, what is it about doing root canals that makes you an expert at examining a bite mark? Nothing, right? You're being hoodwinked.
Interesting. The whole other thing is interesting. So the clients that you have now on death row, where do their cases stand with bite mark evidence?
Well, we have Jimmy Chris Duncan is on death row in Angola, one of the most notorious, outrageous prisons in the United States in Louisiana. It's literally a former slave plantation. And right now, today, there are white men on horseback with shotguns overseeing black men in chains picking cotton, you know what I mean, right now, you know what I mean, in Louisiana. So he's there on bite mark evidence that was created by the notorious Dr. West and a forensic pathologist that was also equally notorious named Stephen Hain, who put him on death row, and he's been there for over 30 years. We have a client in Ohio, Danny Lee Hills, put there by bite mark evidence. And we have Jimmy Rogers in Georgia, all of whom were, whose cases relied on bite mark evidence. You know, and I've been personally involved in 10 exonerations involving people that were put there through bite mark evidence. You know, and Charles McCory, the innocent man in Alabama who's serving life without parole, was the case that Justice Sotomayor wrote about, you know, last summer. So we're still fighting for, you know, his freedom in federal court right now. So, you know, you can see the legacy of junk science. What I worry about in a case like Karen Reed's or any of these cases that are very high profile, if you look at it, a case that you're familiar with, Linda, you know, I mean, is the Casey Anthony case, right?
Right.
Is like in this very high profile case, they were managed to get in despite a very well litigated case by you. is that the smell of death, right? And that was allowed into evidence as scientific evidence, which is total nonsense.
Right,
Still
right.
today, total nonsense, but now it's part of case law. So courts will still use it,
Right.
even though there's no scientific backing. So
Yeah.
you get a case like this, you know, and there is like Mr. Shifazari, one of the is in Massachusetts, spent 37 years in prison for a crime he didn't commit in Massachusetts. That was done entirely by bite mark evidence by Dick Souveron, right? The same guy who testified in the Ted Bundy case. So
And,
what I worry
is he
about,
out? Is he out, the man in Massachusetts?
yeah,
He's
Michael
out, right? That's
Souveron.
recently. He's one of your clients recently exonerated, I guess, in the past 2 years, I think, if I recall.
Yeah, it was the New England Innocence Project that did that. I was not
Yeah.
involved in that case, but he was an innocent man, wrongfully convicted through bite mark evidence. And, you know, what I worry about in a case like this, you know, I mean, is that, you know, where they're going to allow in some sort of dog bite evidence, and we're going to create legal precedent that where people aren't watching the same way that they're watching the Karen Reed case, you know, and it's going to sneak into court because it's been introduced before now, and it'll wrongfully convict somebody.
This, I think, is a different twist on things, Chris. Give me your take on this. Here we have the defense proponent that is going to be arguing that it is bite mark, and in fact has forced the prosecution to come up with their own expert that got it by doing a couple of seminars on YouTube, I think.
Right.
But differently, and then it's not a prosecutor trying to pin a bite on a defendant. It's a defendant using it to come up with a different cause of the injuries to the victim.
Well, the ethics are a lot different because a defense attorney is ethically required to defend their client as zealously as the law will allow. And the law is allowing this, you know, so I'm not faulting the defense for doing their constitutionally obligated duty. What I'm faulting is the courts for allowing subjective speculation masquerading as scientific evidence in front of a jury, you know, so I, you know,
Even
not,
to entertain the issue of whether or not a mold was going to be allowed, a mold of a denture of a dog. I mean, that to me, that was like out of control.
it's great. Yeah. I mean, what the prosecution was trying to do is totally bananas. You know, I mean, you can imagine, you know, as a, you know, there's no expertise that is being used in this case that will advance the search for the truth. There just isn't, because there's no evidence that these experts can do what they claim to be able to do.
That's interesting. So that's the real ethical issue. Of course, you really shine the light on this. I'm going to have everyone look up the New England case. Could you say the name again? So our
Shifazari is Chifarizi, something like that. I'm probably not getting it perfect, but it's in the book.
Gotta be close. Yeah.
It's in your book. And your book's name again?
Junk Science in the American Criminal Justice System.
Thank you.
Such interesting stuff, man. It's no matter how it's used, it is fascinating. And I guess it's only time before we see if somebody's going to take a stand against this and maybe hopefully put you out of business.
That's what I'm here for, right?
Yeah.
You know, it's fascinating the way that a car accident is fascinating.
No one's going to get over Chloe being rehomed. I'm sorry. No one is going to get over that. And in fact, speaking about Chloe, tonight we have a very interesting guest.
Oh, yeah.
Chris Fabricant's going to be on.
What's the last name again? I'm sorry,
Fabricant, Fabricant, and he's got a book out. You can look it on Amazon, talking about junk science. And he was really hired many years ago by the Innocence Project to start the attack on bite mark evidence in humans not being actual science, being junk science that people were convicted on. And he's had a lot of clients that have been released from prison because of wrongful bite mark evidence, which most courts now say is not accurate. Yeah, can you tell a dog bite from a human bite? Yeah, that's probably okay, right. But you can't like say, this is this specific person, this is their bite mark, this matches. And that's where Hank was still trying. The judge said he couldn't get, a specific exclusion, but he's not going to stop. So Chris is just going to talk to us a little bit about bite mark evidence, because the same issues apply even more so in dogs, because there hasn't been those big studies done about how, in the bite marks, your skin moves, right? If things dry up, your skin dries up, even if there is bite marks and all that type of stuff. And when you have a bite, it's a moving situation. We talk about why it was junk science. And if it's junk science for humans, I can imagine it's junk science for dogs. Not the identification of a dog bite. That's different. We're talking something different.
The actual animal that did it.
The actual animal that did it. Exclusion. Maybe you can say inclusion, but you can't certainly say, oh, there's an exclusion here.
This is going to be very interesting, because it's a totally different tact than in trial 1, where they just said you can't prove that's any sort of dog. I mean, that was about it. We think we're going with, shards of taillight did that. We're not moving from that. Now they're opening the door to another possibility, and then saying, but it wasn't Chloe.
Right. Right.
So okay, let's assume they convinced the jury it wasn't Chloe. Okay. So
what is it?
So how did it happen? So that they're going to say, well, by default, if it didn't happen because Chloe nodded this guy, then it clearly must have been the shards of taillight, because when those pieces are gnawing at your arm, oh, Domino got upset there. But the attack taillight.
Domino's, you tell anybody who doesn't know, Domino's your dog.
The taillight's attacking me. I mean, the jury's going to have to believe that. Well, if it wasn't Chloe, then it was a taillight, clearly. So I don't know how that tact by the prosecution wins the day.
I don't understand either how they're planning to do it. And I think, if I recall, their own medical examiners, the one who said it wasn't homicide, indicated, including, and the FBI examiner that the FBI used, the Department of Justice used, said those could be dog scratches and dog bites, right? They indicated that. So I mean, no one's going to exclude them. You just can't say that
it was a specific
dog.
And
the dog is rehomed. It's like, it's like you got rid of your child.
In Vermont, living every day like in fields of poppies. So I can't remember.
With its mouth, by the way, its mouth and its teeth moving, because we all have dogs. We all know as they get older, the teeth kind of like move around.
Just like humans, right. All the variables are overwhelming, from body movement to age change. It's crazy. So I believe they talked about in the first trial that these wounds or caused injuries, whatever they were, antemortem, right? That's what we believe. Okay. So there's probably not going to be a dispute about that. They think it happened when he was alive when the taillight got him.
Right.
Defense say otherwise, alive when the dog got him. Okay. Just want to clear that in my head, make sure there wasn't some argument that he collapsed and was on the front lawn and then along came a wolf.
No dog is coming along in the snow outside with him in the front yard. Those are, if you were in the woods and it wasn't snowing, okay. It could be another animal.
I'm picturing Game of Thrones. I'm picturing Game of Thrones.
Oh, you're dire wolves.
Those what do they call those wolves?
Dire wolves.
Dire wolves that somebody's just rebuilt those, right?
Yeah,
DNA?
but not the big ones. They're the same part of the gray wolf family or something like that, with the dire wolf gene injected. They're not going to be those massive. The dire wolves were like this.
Maybe it'll be a Dighton wolf.
Yeah,
it's a Dighton wolf. It came from neighboring Dighton.
Carlene Barth wants to know if you're coming up on Friday.
Well, I'll be there Friday. So coming up to tomorrow. My days are all messed up because of my weird week. But yeah, coming up tomorrow. Be there 2 days. I think they're going to have a short day Friday. So, you're gone Friday, right? You got the big poker tournament.
Right, Friday.
Miss Shorty will be joining.
Shorty is joining you, right?
So here's what I envision, and I'm just kind of audibleizing right now. I'll be there already in the morning. See what happens then. Get arrested, don't get arrested. Have a show, and then when they break for the day,
if you get arrested while I'm playing a poker tournament, I may just pass out.
Then Miss Shorty will take over the whole operation.
was in fact false.
I misunderstood Mr. Lally's question.
Got it. Thank you.
Okay.
Got it.
Got it.
Got you.
Misunderstood, Mr. Lally. Oh, sure, you misunderstood Mr. Lally's question. When it was finally confronted, but let's assume for the moment, let's give her the benefit of the doubt, because somebody came after me and said, "Oh, she said she misunderstood." You know that? No, I don't know that at all. I think she lied to the grand jury. That's my opinion.
Of course she did. Why did she do it? Because she is a graduate of the Jen McCabe School of Witness Preparation, and she got that lesson down.
But assuming everyone got that, they got this, the feds, this was turned over afterwards. The prosecution had a duty to correct that. They had a duty before she got on the stand to correct that, not to put her on the stand, let her repeat the same thing, or open with Jen McCabe is Karen Reed calls these Google searches, because Karen Reed was directing everyone to do these Google searches. They didn't do that. And so I'm asking you, Judge Beverly Cannone, flat out, and if you want to cut this tomorrow, cut this, okay? But I'm asking you, Judge Cannone, flat out, when we teach ethics at Harvard to those young students at the trial advocacy workshop, when some of them are going to be prosecutors, don't we teach them that they have a duty to justice, they have a duty to truth, and shouldn't the prosecution have come forward? And since they did not come forward and say that, and they have misrepresented things to the jury, why don't you have the same level of concern, and why don't you go sanctioning those prosecutors? Why doesn't Mr. Lally, who's been seated in that courtroom, stand up there and Mr. Lally say, this, by the way, Hank Brennan, when you opened to the jury, letting the jury believe that Jennifer McCabe was ordered by Karen Reed to do those Google searches, why don't you stand up and say that was not true?
Yeah, we know why, but I know your question's rhetorical. We know why, because she doesn't want to, because it would be helpful for the defense. And it's also important to know, we're going to hear from Jen McCabe personally, directly, that she heard Karen Reed ask the Google search request.
That's their way out, right?
That's
going to be their way out.
Exactly right. Because they're going to just say, well, we had other testimony from the person who actually heard it. It's unfortunate that Ms. Roberts didn't understand the question and incorporated Jennifer McCabe's understanding and hearing into her response. That's how it gets a little messy. But I can't wait to hear Jen McCabe go through this again and start talking about, as we've talked about, how you conflate. I'm stealing some of Jackson's words. How you conflate hypothermia with how long to die in the cold. How do you twist that? If in fact she said hypothermia, in your brain, how does that become how to die in the cold? I don't know. Okay, so.
Only fan, only fan, only fan. Only fan, only fan, only fan. Only fan, only fan, only fan. been 84 years.
One eternity later. One eternity later. One eternity later. 2 hours later.
Beverage goblin needs at least 3 drinks at a time. She needs them while she's working for her body and mind. 1 to hydrate, 1 to energize, and 1 just for fun. A beverage goblin needs her beverages to make her brain run.
All right.
Please be seated, court is in session.
Could I see counsel for a minute regarding scheduling, please?
please?
They're on the way around.
Okay, thank you.
All rise for the court, please. Your attention.
Only fan, only fan, only fan.
Goes back to section 8, may be seated.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good afternoon. Just a few more items I'd like you to recognize. Your Honor, may I approach?
Yes.
Showing you an envelope. Do you know what's in that envelope?
Yes, the raw data extraction of John O'Keefe's cell phone.
Your Honor, I'd ask it to be marked simply for identification, please.
Okay.
Exhibit A, identification.
Thank you.
Second folder.
Yes, the raw data extraction of Jen McCabe's cell phone that I created.
Thank you, sir. Your Honor, I'd ask it to be marked for identification as well.
All right.
Exhibit B for identification.
Thank you.
Trooper, you shared with us that you downloaded the extraction of the phones that you identified and you made reports based on specific identified features, for example, a conversation between two people.
Yes, so I didn't do the extraction of Jen's phone, but I made those reports with the PDFs from the data extraction.
Relative to Mr. O'Keefe and the defendant's phones, you created a document that provided us the phone calls between them on January 29th?
Yes, that's correct.
And separately, you also provided a document that included all of the chats or text messages between John O'Keefe and the defendant on January 29, 2022.
Yes, it also included the 28th.
Thank you.
Yes.
And in that compilation, did you put together or do you create or review a PowerPoint of those?
Yes, I did.
And what was the point of that?
Just to show the texts and calls in a chronological order, because that way you're not looking at two different documents, trying to compare and contrast the calls to text messages when each is coming in.
And did you begin that PowerPoint presentation with a call at 2:16:10 on January 28, 2022?
Yes, that's correct.
And are there additional chats or text messages earlier that morning?
Yes, there's a handful starting around 9:45 a.m.
May I
Yes.
approach, Your Honor?
Yes.
Handing you a folder, sir. Could you take a look at it? Let us know if you recognize what's in it.
Yes. So this is the bulk of this is the PowerPoint calls and text messages, and at the beginning, there's the messages from before 2:16 in the morning.
I'd like to introduce this as an exhibit, Your Honor.
Okay.
No objection, Your Honor.
Great, thank you.
Exhibit 33.
For permission, I'd ask the witness to read the text messages from the morning hours, and then we begin the PowerPoint presentation.
Okay.
Thank you, Your Honor.
Do you have a hard copy of those for me?
It was provided. I'll see if we have another copy if you don't have it.
All right, I have, it's in here, the pre-morning hours. The ones that we discussed at Sidebar. If you don't have them,
The defense has a copy for you, Your Honor.
thank you.
Madam? I'm sorry.
Thank you, Ms. Little.
Thank you.
May we begin, Your Honor?
Please.
Could you first read the text messages from that morning to the jury?
Yes. Apologize if I misspelled things or state things. Start time, all right. It's a little different than the format I had before. All right, this is from Karen Reed to John O'Keefe. You have really hurt me this time. This was sent at 9:49:20 a.m. on the 28th. From John O'Keefe to the defendant, I'm sorry, this has been an issue with me for 8 years. It physically hurts me to see everyone else in their life do things for them, and I'm forced to always be the bad guy. This was sent at 10:02:56 a.m. on the 28th. From the defendant to John O'Keefe, I'm not the same as everyone else. Most of the time I try to do what is healthy/smart for them. More importantly, I try to support you in what you need. You just lashed out at me and said terrible things. I don't know how you've gotten to this point with me when I'm just trying my hardest. You made your point and continue to beat me down. I have a lot going on too. Physically, I am falling apart and trying to get answers and help. 10:09:49 a.m. on the 28th. From the defendant to John O'Keefe, I am just your girlfriend. I am not a perfect parent. I am trying very hard and sometimes treat them nothing like I used to. 10:46 a.m. on the 28th. From John O'Keefe to the defendant, I know, I'm sorry for lashing out. I'm just hurting and struggle daily with them. Always feel like I'm failing at this parenting thing. I wasn't built for this. 10:12 a.m. on the 28th. The defendant to John O'Keefe, Kaylee isn't perfect, but everything wonderful about her is because of you. 12:21:36 p.m. on the 28th. From John O'Keefe to the defendant, an emoji is sent at 12:21:59 on the 28th. From the defendant to John O'Keefe, it's true, I know she's her mother's daughter, but she wouldn't be so bright and successful if she lived with anyone else. 12:22:51 p.m. on the 28th. From the defendant to John O'Keefe, wow, Kristen just sent 2 back-to-back messages to not lose your faith in the kids. 12:31:28 p.m. on the 28th. From the defendant to John O'Keefe, or in yourself, at 12:31:41 p.m. on the 28th. From John O'Keefe to the defendant, there's 2 emojis sent at 12:32:06 p.m. on the 28th. From the defendant to John O'Keefe, no, and there's 2 emojis. Life can pick you up sometimes. Please be happy with them and put away your frustrations for the rest of the day. And be so proud of yourself, JJ. That's 12:33:35 p.m. on the 28th. From John O'Keefe to the defendant, that's what bothers me more than anything. Should have sent Peg's or Sarah's W-2s. We're all equal guardians. 1:18:21 p.m. on the 28th. From the defendant to John O'Keefe, maybe you can call someone. 1:21:55 p.m. on the 28th. From John O'Keefe to the defendant, like who? 1:46:42 p.m. on the 28th. From John O'Keefe to the defendant, what time are you coming here? 1:47:38 p.m. on the 28th. From John O'Keefe to the defendant, it's another emoji sent, 2:05:30 p.m. on the 28th. From the defendant to John O'Keefe, I don't know what time, feel kind of out of it, just trying to clear my head, 2:06:07 p.m. on the 28th. From John O'Keefe to the defendant, he writes, okay, 2:06:25 p.m. on the 28th. From the defendant to John O'Keefe, text me when you guys settle in later, 2:06:44 p.m. on the 28th. From John O'Keefe to the defendant, sure, 2:06:58 p.m. on the 28th. From the defendant to, oh, no, it's cut off here, sir.
Yeah. May I approach, Your Honor?
Yes.
That must be where the, so,
Would it be helpful if I take it out of the binder for you?
I believe it goes to the next one, so I'll start. Yeah, sorry.
With the court's permission, we'll begin the PowerPoint.
Yes.
At your leisure.
Okay. The phone calls, text messages, and then we'll start with the first slide. This is from the defendant to John O'Keefe. I feel pretty shitty about how this morning went down. I know you said sorry, but it really stung, especially when I've been trying pretty hard lately. I feel like a loser turning around, just coming back over after everything you said. 2:10 p.m. on the 28th. From John O'Keefe to the defendant, not sure what you want me to do. I said I'm sorry and I was out of line. If you prefer to stay home, I totally get it. 2:16 p.m. on the 28th. From the defendant to John O'Keefe, things in my own life have been difficult too, you know. 2:17:33 p.m. on the 28th. From John O'Keefe to the defendant, I know. 2:17:40 p.m. on the 28th. At 2:17:45 p.m., the defendant calls John. The phone call is answered and they speak for 2 minutes, 22 seconds. 2:23:02 p.m., the defendant calls John. That's again answered. At 1:00, and they speak for 1 minute, 2 seconds. At 2:24:17 p.m., the defendant calls John, and the call is rejected. From the defendant to John O'Keefe, tell me if you're interested in someone else. Can't think of any other reason you've been like this. 2:25:18 p.m. on the 28th. From John O'Keefe to the defendant, nope. 2:25:33 p.m. on the 28th. From John O'Keefe to the defendant, things haven't been great between us for a while. Ever consider that? 2:26:03 p.m. on the 28th. At 2:28:40 p.m., the defendant calls John. That call is rejected.
Mr. Greeno, can you explain to us the difference between not answered and rejected?
Yes, so if the call is not answered, that means the call rang out and goes to voicemail. If the call is rejected, that is someone actively hitting the send to voicemail button to disable the call, to stop it from ringing. From John O'Keefe to the defendant, kids are here, not in the mood to talk. 2:29:03 p.m. on the 28th. From the defendant to John O'Keefe, so you're not into it anymore. That's fine, but I don't want to keep trying and you keep treating me like this. 2:29:12 p.m. on the 28th. From the defendant to John O'Keefe, I'm trying to hug and kiss you this morning and you whack me in the face with a pillow. 2:29:59 p.m. on the 28th. From the defendant to John O'Keefe, last night you're basically like, yeah, what about when we talk about the future? So why don't you just admit you're not into so much anymore? 2:23 p.m. on the 28th. From John O'Keefe to the defendant, not how it went down, but okay. 2:26 p.m. on the 28th. From the defendant to John O'Keefe, can you please admit your head is out of the game with us? 2:52 p.m. on the 28th. John O'Keefe to the defendant, sick of always arguing and fighting. It's been weekly for several months now. So yeah, I'm not as quick to jump back into being lovey-dovey as you apparently. 2:32:28 p.m. on the 28th. At 2:32:47 p.m., the defendant calls John. That call is rejected. John O'Keefe to the defendant, OMG, stop calling. 2:32:54 p.m. on the 28th. From the defendant to John O'Keefe, then why would you start with me this morning? 2:32:58 p.m. on the 28th. From the defendant to John O'Keefe, you're setting me up to fail. 2:33:05 p.m. on the 28th. From the defendant to John O'Keefe, you started a number of fights from your end. 2:33:26 p.m. on the 28th. And John O'Keefe to the defendant, I've explained it a few times already, not doing it again. 2:33:31 p.m. on the 28th. From the defendant to John O'Keefe, so you're not into this anymore. 2:33:41 p.m. on the 28th. From John O'Keefe to the defendant, not into fighting all the time, correct. 2:34:03 p.m. on the 28th. From the defendant to John O'Keefe, if you tell me you're interested in someone else, You will never hear from me again. You can have all the space in the world. 2:34:11 p.m. on the 28th. From John O'Keefe to the defendant, he sends an emoji. 2:34:19 p.m. on the 28th. From the defendant to John O'Keefe, then stop starting with me. 2:34:20 p.m. on the 28th. 2:34:29 p.m. the defendant calls John. He rejects the call. John O'Keefe to the defendant. I'm not answering. Stop calling. 2:34:42 p.m. on the 28th. From the defendant to John O'Keefe, can you please answer after how you treated me earlier? 2:34:43 p.m. on the 28th. 2:34:54 p.m. the defendant calls John. That's rejected. John O'Keefe to the defendant. Kaylee is right here. 2:35:02 p.m. on the 28th. The defendant to John O'Keefe. You start a rager with me out of nowhere and then tell me you're sick of fighting with me. 2:35:41 p.m. on the 28th. The defendant to John O'Keefe. I'm going to grab a drink in a bit. 2:38:14 p.m. on the 28th. 2:38:42 p.m. the defendant calls John. That call is rejected. The defendant to John O'Keefe, can you please answer? 2:38:52 p.m. on the 28th. From John O'Keefe to the defendant, no Karen, not sure why you need to announce that you're going, not sure why you need to announce that you're grabbing a drink, but have fun. 2:39:46 p.m. on the 28th. From the defendant to John O'Keefe, seeing if you want to meet me later. 2:40:22 p.m. on the 28th. From the defendant to John O'Keefe, can you please call me? 2:40:32 p.m. on the 28th. From John O'Keefe to the defendant, have to take them to the doctor, he has practice. 2:40:55 p.m. on the 28th. From the defendant to John O'Keefe, yeah, 5 minutes. 2:41:17 p.m. on the 28th. At 2:43:01 p.m., the defendant calls John. It's not answered. At 2:43:45 p.m., the defendant calls John. The call is rejected. John O'Keefe to the defendant. My father just walked in. 2:43:58 p.m. on the 28th. The defendant to John O'Keefe. Okay, can you please call me for 2 minutes? 2:44:14 p.m. on the 28th. John O'Keefe to the defendant. Not right now. 2:44:23 p.m. on the 28th. The defendant to John O'Keefe. I'm there when anyone else needs me. 2:44:26 p.m. on the 28th. At 2:45:32 p.m., the defendant calls John. The call is rejected. The defendant calls Mr. O'Keefe. Yes, John, you gave me utter grief this morning. I'd like you to call me for a minute. 2:46:16 p.m. on the 28th. The defendant to John O'Keefe. I've been trying to get over the hump with is arguing, and now you tell me you're not into doing things, and you don't want to fight weekly, but fly off the handle at 8 a.m. with me, like you're setting me up to fail. 2:47:08 p.m. on the 28th. The defendant to John O'Keefe. I've been dealing with my own personal crisis over things I have zero control over. I'd like to lean on you too sometimes. Instead, I just hear everything I've done wrong. 2:48:34 p.m. on the 28th. At 2:56 p.m., the defendant calls John. The call is rejected. At 2:51:13 p.m., the defendant calls John. It's rejected. 2:52:37 p.m., John calls the defendant. It's not answered. At 2:53:56, the defendant calls John. Again, not answered. The defendant, John O'Keefe, you seriously cannot pick up the phone for 2 seconds. 2:54:13 p.m. 2:58:05 p.m., the defendant calls John. It's rejected. At 2:59:13, John calls the defendant. The call is answered and they speak for 4 minutes, 59 seconds. From the defendant to John O'Keefe, why don't you meet me at Hillside at 4:30/5, 3:08:55 p.m. John O'Keefe to the defendant, sends an emoji at 3:10:08 p.m. on the 28th. From the defendant to John O'Keefe, or whenever you get, or whenever you get everyone settled, 3:10:35 p.m. on the 28th. From John O'Keefe to the defendant, like I said, doctor now, and he has practice till 6. If you want to go start drinking, then go for it. 3:36:21 p.m. on the 28th. The defendant to John O'Keefe, I didn't know the times of his practice. 3:36:40 p.m. on the 28th. The defendant to John O'Keefe, I just want to give you space at the house without me there. So rather meet you out than meet at the house. 3:37:01 p.m. on the 28th. John O'Keefe to the defendant, yeah, well now there's a 72-year-old taking up shop on my couch. 3:37:36 p.m. on the 28th. The defendant to John O'Keefe, yeah, that too. 3:37:46 p.m. 28th. From the defendant to John O'Keefe, is he going to Collins? 3:38:23 p.m. on the 28th. John O'Keefe to the defendant, not tonight. 3:38:32 p.m. on the 28th. From the defendant to John O'Keefe, so do you plan on going out tonight? 3:39:01 p.m. on the 28th. From John O'Keefe to the defendant, Karen, I don't know. 3:39:17 p.m. on the 28th. John O'Keefe to the defendant, you're like jonesing to drink, so go. 3:39:43 p.m. on the 28th. From the defendant to John O'Keefe, okay, well after how this morning went down, I don't think I need to be back over there with you get frustrated at how I am with the kids. Has nothing to do with drinking. 3:40 p.m. on the 28th. From the defendant to John O'Keefe, I am paranoid now that everything I do with them is problematic, so rather see you for a minute without it, kids around. 3:40:24 p.m. on the 28th. From John O'Keefe to the defendant, what's your plan at 4:47:16 p.m. on the 28th? From the defendant to John O'Keefe, don't have one, 4:50:09 p.m. on the 28th. From John O'Keefe to the defendant, so still home, 4:50:26 p.m. on the 28th. The defendant to John O'Keefe, yes, 4:50:45 p.m. on the 28th. From John O'Keefe to the defendant, we just got home, waiting to see what Papa decides here or else I have to get Patrick at 6. 4:59:45 p.m. on the 28th. The defendant to John O'Keefe, okay, 5:01:55 p.m. on the 28th. John O'Keefe to the defendant, so are you staying home or coming here? 5:02:23 p.m. on the 28th. From the defendant to John O'Keefe, waiting to see what you end up doing. I don't want to hang out at the house too much, like I said. 5:03:40 p.m. on the 28th. From the defendant to John O'Keefe, I think it's clear me around with the kids around is slowly killing our relationship, and our relationship is much more important to me. 5:04:16 p.m. on the 28th. John O'Keefe to the defendant, well, there's a blizzard coming, so we'll be inside all weekend. 5:04:19 p.m. on the 28th. The defendant to John O'Keefe, it will be over by noon tomorrow. 5:04:44 p.m. on the 28th. John O'Keefe to the defendant, don't think so. 5:05:27 p.m. on the 28th. The defendant to John O'Keefe, I don't want to keep having this constant conflict of the dynamic of the four of us. The harder I try, the more it kills our relationship as a couple. It feels like utter shit to be in that position. Rather just meet you out for drinks when you figure out what your night looks like. 5:06:45 p.m. on the 28th. John O'Keefe to the defendant, well, I have no idea what's going on, so do what you want. 5:07:34 p.m. on the 28th. John O'Keefe to the defendant, need to figure out what everyone here is doing. All I know now is Madeline is coming over. No clue about Patrick yet, or if Papa is planning on hanging it for a few more hours. 5:29 p.m. on the 28th. From the defendant to John O'Keefe. Okay, well, when you know the story, and if you want me to come up, let me know. 5:36 p.m. on the 28th. John O'Keefe to the defendant. No, Karen, you decide what you want to do. 5:18 p.m. on the 28th. From the defendant to John O'Keefe. I know your heart isn't in this anymore. I felt it for a while, and especially lately. I'm willing to try more, but not if you approaching the point of indifference. If you want me to come up and you can head out for a while, then say so when you know what your father is doing. 5:23 p.m. on the 28th. John O'Keefe to the defendant. You come up and I head out. Really? Emoji. 5:48. John O'Keefe to the defendant. I've told you already, I don't bounce back as quickly as you do after we have a battle. 5:52 p.m. on the 28th. From the defendant to John O'Keefe, no, head out together with an emoji. 5:49 p.m. on the 28th. From the defendant to John O'Keefe, or meet out. 5:54 on the 28th. John O'Keefe to the defendant, gonna send Patrick to Collins tonight. They're picking him up around 7. Mike may hang out too when he brings Matt over. So why don't you just come over? 5:42 p.m. on the 28th. From the defendant to John O'Keefe, Mike doesn't want to go out for a bit. 5:20 p.m. on the 28th. From the defendant to John O'Keefe, I would like to, been a shit day from the jump. 5:33 p.m. on the 28th. From John O'Keefe to the defendant, probably 5:39 p.m. on the 28th. From John O'Keefe to the defendant, I just got sober an hour ago. 5:56 p.m. on the 28th. From the defendant to John O'Keefe, I'll text you, hang with Mike for a few. I don't need to butt in. Text me if/when you think you may head out. 5:12 p.m. on the 28th. From the defendant to John O'Keefe, can you send me Tim Zoll's contact info, please? 5:38 p.m. on the 28th. John O'Keefe to the defendant, I paid the last bill. 5:27:08 p.m. on the 28th. From the defendant to John O'Keefe, you didn't have to do that, thanks. 5:27:43 p.m. on the 28th. From the defendant to John O'Keefe, are you really not going to accept my friend request? 5:33 p.m. on the 28th. From John O'Keefe to the defendant, an emoji on what, FB? 5:33:01 p.m. on the 28th. From the defendant to John O'Keefe, yeah, we've been going out for 2 years. 5:33:20 p.m. on the 28th. John O'Keefe to the defendant, I haven't gone on. You defriended me over a year ago, I believe. 5:33:48 p.m. on the 28th. From the defendant to John O'Keefe, Kerry texted that they're headed out in a bit. 6:05:29 p.m. on the 28th. From John O'Keefe to the defendant, okay. 6:14:55 p.m. on the 28th. From the defendant to John O'Keefe, she's going to let me know where. 6:17:51 p.m. on the 28th. From John O'Keefe to the defendant, so you're going to meet them. 6:18:12 p.m. on the 28th. From the defendant to John O'Keefe, just presenting it as an option. Wouldn't mind hanging out with them for a drink. 6:19 p.m. on the 28th. Sorry. From the defendant to John O'Keefe, is Mike over? 6:27:26 p.m. on the 28th. From John O'Keefe to the defendant, yes. 6:29:45 p.m. on the 28th. From the defendant to John O'Keefe, sounds you're like good with getting together tonight. 6:31:32 p.m. on the 28th. From the defendant to John O'Keefe, was hoping after this morning you'd be interested in smoothing things over with me. 6:32:24 p.m. on the 28th. John O'Keefe, the defendant, told you to come over, but you insisted on meeting me out somewhere. 6:33:44 p.m. on the 28th. From the defendant to John O'Keefe, Mike is a little off with me for a while now. I've said that multiple times. 6:34:34 p.m. on the 28th. From John O'Keefe to Karen, the defendant, time to get over it, Karen. He's fine. He was fine the other night when he came by. 6:38:09 p.m. on the 28th. From the defendant to John O'Keefe, yeah. Where are you meeting them? 6:39:28 p.m. on the 28th. From the defendant to John O'Keefe, I don't have plans with them. She just said they're headed out in a bit and will text when they land somewhere. 6:39:52 p.m. on the 28th. From the defendant to John O'Keefe, if you want to go out with Mike solo, that's fine. Just let me know. 6:40:17 p.m. on the 28th. From John O'Keefe to the defendant, I already told you what you should do. Not going to keep doing this. 6:41:07 p.m. on the 28th. From the defendant to John O'Keefe, I asked to let me know if you guys are going to head out. I haven't been out for drinks this week and had a shit week and a shit day. And I dread Kaylee or Pat is going to get chatty with me the second I walk in, and that is going to irritate you. 6:43:21 on the 28th. From John O'Keefe to the defendant, Pat is leaving, Kay is with Mad Cam. 6:44:02 p.m. on the 28th. John O'Keefe to the defendant, I'll text Chris then. 6:46:44 p.m. on the 28th. John O'Keefe to the defendant, we're headed out shortly. What's your plan, Karen? 7:06:13 p.m. on the 28th. From the defendant to John O'Keefe, do you want me to join or no? 7:06:37 p.m. on the 28th. From John O'Keefe to the defendant, yes, wasn't sure if you were meeting the Currans. 7:07:04 p.m. on the 28th. From the defendant to John O'Keefe, they are not out drinking yet. 7:07:40 p.m. on the 28th. From the defendant to John O'Keefe, where are you headed? 7:09:22 p.m. on the 28th. John O'Keefe to the defendant, trying to decide maybe McCarthy's. 7:14:48 p.m. on the 28th. From the defendant to John O'Keefe, okay then, let me know where you decide. I'm still down in Enfield. 7:21:50 p.m. on the 28th. From John O'Keefe to the defendant, text me when you leave. Still waiting on McKinney's. 7:22:28 p.m. on the 28th. From the defendant to John O'Keefe, I'm having issues with my hot water, so had to text someone to take a look. 7:24:11 p.m. on the 28th. John O'Keefe to the defendant, an emoji, you trying to piss me off. 7:25:35 on the 28th. John O'Keefe to the defendant, hope your plumber buddy that you texted is hot. 7:26:24 p.m. on the 28th. From the defendant to John O'Keefe, nope, my shower only got lukewarm and now my sink won't run hot at all. The plumber I used is right down the road. 7:26:27 p.m. on the 28th. From the defendant to John O'Keefe, I turned that temp thing in the basement all the way up. 7:26:52 p.m. on the 28th. John O'Keefe to the defendant, check the hot water heater and see if it's leaking. 7:26:50. John O'Keefe to the defendant, check the hot water heater and see if it's leaking. 7:26:52 p.m. on the 28th. The defendant to John O'Keefe, it's not. 7:26:59 p.m. on the 28th. John O'Keefe to the defendant, don't do that, 7:27:01 p.m. on the 28th. John O'Keefe to the defendant, is the pilot lit, 7:27:08 p.m. on the 28th. From the defendant to John O'Keefe, I was trying to get my shower hot, 7:27:12 p.m. on the 28th. From the defendant to John O'Keefe, yes, 7:27:14 p.m. on the 28th. From John O'Keefe to the defendant, don't turn it up, don't turn it all the way up, 7:27:26 p.m. on the 28th. John O'Keefe to the defendant, it will burn out, 7:27:32 p.m. on the 28th. From the defendant to John O'Keefe, I had this issue twice before and it wasn't a disaster. I just can't remember what the cause was, 7:27:41 on the 28th. From John O'Keefe to the defendant, just turn it back to where it was and get over here, 7:28:08 p.m. on the 28th. From the defendant to John O'Keefe, I don't want to come home in a blizzard and then really be up shit creek, 7:28:53 p.m. on the 28th. John O'Keefe to the defendant, so you're going home tonight, 7:29:18 p.m. on the 28th. From the defendant to John O'Keefe, or tomorrow or whenever. I've had a chill all day since my shower, 7:29:45 p.m. on the 28th. From John O'Keefe to the defendant, it's going to snow all day tomorrow, no driving, 7:30:05 p.m. on the 28th. From John O'Keefe to the defendant, we're headed to McCarthy's, 7:41:29 p.m. on the 28th. From the defendant to John O'Keefe, okay, let me know if you end up leaving, 7:41:57 p.m. on the 28th. From John O'Keefe to the defendant, why? Now you're not coming, 7:42:27 p.m. on the 28th. From the defendant to John O'Keefe, I'm waiting for the plumber. I actually think he's in the driveway, 7:42:56 p.m. on the 28th. From John O'Keefe to the defendant, we're taking Mike's car, so I'm relying on you for a ride home if he leaves, 7:43:10 p.m. on the 28th. From the defendant to John O'Keefe, he's not going home after, 7:43:27 p.m. on the 28th. John O'Keefe to the defendant, 8 o'clock on a Friday, emoji, 7:43:31 p.m. on the 28th. John O'Keefe to the defendant, you may have to get Michael, 7:43:46 p.m. on the 28th. John O'Keefe to the defendant, you have a plumber coming over at 8, knowing me and Papa could have handled it. Good luck, 7:44:36 p.m. on the 28th. From the defendant to John O'Keefe, I have always told you I will not put either of you out of your way the way everyone else in your life does. I knew it wasn't working right when you were at the doctor's with Kaylee, and I knew neither of you could get here. And this guy Richie fixed it last time, whatever it was. He was supposed to be here at 5, 7:48:01 p.m. on the 28th. From the defendant to John O'Keefe, if it's not a quick fix, I'll tell him to forget it, 7:48:20 p.m. on the 28th. John O'Keefe to the defendant, if you need a new water heater, don't let him do it, 7:55:04 p.m. on the 28th. The defendant is from the defendant to John O'Keefe. He's here now. If it's not quick, I'm not doing it. I just want to make sure nothing is wrong / will go wrong with when I'm not home, 7:55:44 on the 28th. From the defendant to John O'Keefe, he's not a scammer. Half the quick stuff he doesn't even charge me for, 7:56:06 p.m. on the 28th. From the defendant to John O'Keefe, he just put the toilet seats on crooked, 7:56:28 p.m. on the 28th. John O'Keefe to the defendant, status, 8:09:02 p.m. on the 28th. And the defendant to John O'Keefe, still here with an emoji, 8:09:18 p.m. on the 28th. From the defendant to John O'Keefe, said he's got to go to HD and probably be back mañana. 8:23:56 p.m. on the 28th. From John O'Keefe to the defendant, so 8:24:43 p.m. on the 28th. From the defendant to John O'Keefe, an emoji, 8:25:02 p.m. on the 28th. From the defendant to John O'Keefe, just trying to figure out if I need to be here, 8:25:51 p.m. on the 28th. From John O'Keefe to the defendant, what does it need, 8:26:01 p.m. on the 28th. From the defendant to John O'Keefe, I don't know. He showed me some pieces that was all rusted, with an emoji. I don't understand half this stuff, 8:26:42 p.m. on the 28th. John O'Keefe to the defendant, on the water heater, 8:26:59 p.m. on the 28th. From the defendant to John O'Keefe, yes, 8:27:08 p.m. on the 28th. From John O'Keefe to the defendant, tell him to leave it. I'll take care of it Sunday or Monday, 8:28:30 p.m. on the 28th. From the defendant to John O'Keefe, no, it's okay. I can either meet him here or just shut off the alarm, 8:28:52 p.m. on the 28th. From the defendant to John O'Keefe, he used to work here while I was at work, 8:29:02 p.m. on the 28th. From John O'Keefe to the defendant, does he realize it will be whiteout conditions tomorrow a.m., 8:29:32 p.m. on the 28th. From the defendant to John O'Keefe, yeah, but he lives right down the road, 8:29:47 p.m. on the 28th. From John O'Keefe to the defendant, Karen, this storm is going to be intense, can't drive, 8:30:19 p.m. on the 28th. From the defendant to John O'Keefe, okay, well, if he can't, he can't, 8:30:36 p.m. on the 28th. John O'Keefe to the defendant, I'll do it Monday, 8:30:56 p.m. on the 28th. From the defendant to John O'Keefe, I better not still have this problem on Monday, 8:31:22 p.m. on the 28th. From John O'Keefe to the defendant, I plan on being there, 8:31:43 p.m. on the 28th. From the defendant to John O'Keefe, I'd to know I can take a hot shower there here if I need to, 8:32:14 p.m. on the 28th. Figured you'd be, from John O'Keefe to the defendant, figured you'd be in Canton until Monday, 8:32:32 p.m. on the 28th. From John O'Keefe to the defendant, I'm getting off my phone. Let me know what you're doing, 8:32:54 p.m. From the defendant to John O'Keefe, I think the four of us together is toxic to this relationship. Would like to limit it, 8:33:16 p.m. on the 28th. From the defendant to John O'Keefe, you said so yourself for probably a year now, 8:33:52 p.m. on the 28th. John O'Keefe to the defendant, blizzard tomorrow, nobody is going anywhere, 8:33:56 p.m. on the 28th. From the defendant to John O'Keefe, maybe I'll come back late tonight. Bad snow is in the early a.m.
Snow?
8:35:14 p.m. on the 28th. From the defendant to John O'Keefe, I'll head up there in a few min. Let me know if you leave, 8:35:26 p.m. on the 28th. From John O'Keefe to the defendant, an emoji, he says sure, 8:35:34 p.m. on the 28th. And that was the last of them.
We're almost done, sir.
And you can feel free to stand.
Okay, thank you, Your Honor.
So that presentation is a compilation of text messages and phone calls between John O'Keefe and the defendant on January 28, 2022.
Yes, that was.
Aside from that compilation, are there other text messages and phone calls that you've reviewed between John O'Keefe and the defendant that evening, January 28, 2002, going into past midnight, January 29, 2022.
Yes, there's more text messages.
And those text messages and phone calls, are they a separate compilation from this?
Yes, that's correct.
All right, this time I'd ask us to release Trooper Garino and recall him at a later date.
Yes. All right. There's no objection, Mr. Alessi, correct?
No objection, subject to prevention.
Yes. All right. Thank you very much, Trooper. We'll see you another time.
Thank you, Your Honor.
You just leave it.
I got it. Thanks.
Is this the time for me to see counsel at sidebar?
You'll have a little
Okay.
exhibits, Your Honor, may I?
Yes.
Your Honor, I'm going to introduce exhibits or clips 7 through 11.
Thank you.
With the court's permission, could I begin with clip 7?
Yes.
When you walked out of the bar, how many drinks had you had?
I have had probably about 4, and not 4 that I completed either. I didn't drink maybe more than a few sips at the waterfall.
And 4 drinks you felt fine to drive?
Yep.
Clip 8, please.
Okay.
And is the level of intoxication pretty high here for everybody?
It's happy.
Yeah.
It's,
Because you'd had a lot to drink, right?
I wouldn't say, I'd have like a normal amount. Like a vodka tonic every 40 minutes.
Okay. And so are you feeling like buzzed? And I'm not judging, I'm just trying to get a
Yeah,
sense.
buzzed.
Yeah.
Clip 9, please.
The final count of my alcohol intakes, probably about 5 or 6 or 4. The drinks that they were pouring me at McCarthy's, which is where I consumed most of the alcohol, was the weakest vodka tonic. It tasted just like old soda water with lime. Not that I need it to be a martini, but it might have had a splash of vodka in it. So I said, John, this drink tastes like it has no vodka in it. He said, just get a shot and mix it yourself. So each drink was being counted as a double. So I would get a vodka tonic and then I would pour a shot into it. So that would come as 2. But frankly, it just felt like a regular cocktail. It was just a really weak pour. So I asked for a shot. So for my taste, it just tasted like that's the normal strength of what a drink should be. So I had maybe 2 or 3 that are being counted as 4 and 6. And I don't know. I felt fine. I felt like I was buzzed. And then there was one drink, the last one that was given to me, which I would have counted as 3, but they're counting as my 6th cocktail. The guys that we were with brought around the shots, and they gave me one that I didn't drink, but I poured it in my drink. So that's now my 5th and 6th drinks, with the 7th, which is a shot that all the men did, and I poured it. So that one glass that I'm holding, that I go into the waterfall with, has 3 drinks in it, a vodka tonic and 2 shots. And which is why John said to me, you're not leaving that drink here, like you haven't touched it and just poured a bunch of vodka. He's like, just take it with you, which was something he always did. So then I go into waterfall, and I put that drink down, and I socialize most of the time. So that would have been my 5th, 6th, and 7th drinks. Then John orders me a drink at the waterfall that I don't drink, that he takes with him. And then there was a round of shots that Chris Howard bought that I did take. So that would have been the night. But I did not consume 9 vodka martinis or take 9 shots, depending on how you count it. And the last 2 drinks I didn't touch.
Clip 10, please.
would be if I hadn't been drinking. I mean, I had drank, so, and that led me to question, like, could I have hit him? Did I run over his foot or hit him in the knee? Did I incapacitate him? I mean, I always drive with my music blasting ever since I was 16. And I know when John got out of the car to go into Fairview, I know my car was blasting because when I got in it the next morning to go look for him, I had to immediately turn it down. And I don't know, it's stormy. I have had a few cocktails. I didn't black out, but I wasn't as lucid as I would have been if I had gone to bed at 9 and drank a tea. But so I was fuzzier than I would have been if I had had no alcohol.
Clip 11, please.
How did you feel after that many drinks? When you got in the car, did you feel like you could drive? And did you feel how
I wouldn't have gotten on the expressway. I wouldn't have gotten on the expressway at 12:15 on January 29th. I mean, it was quiet. The roads were very quiet. You can see it on the videos. And I was going, you know, when I've had a few drinks and I drive, I always drive extra slow. So I know my alerts aren't as sharp as they should be. But I shouldn't have been driving. But I don't think I was driving. I know I wasn't driving recklessly. I mean, I've got plenty of video of myself driving all over the place. I put my car in John's garage, which is incredibly narrow, and I had a very oversized SUV. You see me, there's a video of me driving through the intersection when we leave Waterfall to go to Brian Albert's, and I was always taught by my father, even when you have a green light, you always should tap the brake, and you don't know who's going to run red. And I see me doing that multiple times between 12 and 1 and 5 and 6 a.m. So I know I was driving safely, not as safely or as alert as I would be if I had no alcohol. But I was not driving recklessly by any measure.
Thank you. Your Honor, may we approach?
Yes.
Okay. Come on.
Yeah.
All right, jurors, there was some confusion with counsel regarding witnesses. So those are the witnesses for today, so we're done for today. Counsel assures me that won't happen again, but more importantly, we're on track. We're on schedule, not going for the rest of the day, won't interfere with our schedule at all. It looks like it's, I can't tell with all the curtains here, but it looks like it's a beautiful day. You'll have a nice afternoon. Tomorrow we'll be going on a view. So for that, we're comfortable clothes. We'll be walking around a little bit. We'll be going by bus, and I'll have more instructions for you tomorrow morning. But please follow those instructions. Do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, read anything about this case, please disregard it and let us know, and we'll see you tomorrow morning. Remember, tomorrow's the hot day.
All rise for the court, please. Close your notebooks and follow me.
jurors exit the courtroom.
All right. Mr. Brennan, have you had an opportunity to think about whether experts should be permitted to either be present or watch the proceeding? And I also want to know, are you expecting to put on any expert testimony tomorrow?
Dr. Fowler will testify tomorrow. I think that should be considered expert testimony. He provides the procedures and protocol for the testing of blood serum.
Okay.
So I think he's technically considered an expert, although one of the briefer ones.
All right. Does the defense want an expert to be able to watch that? All right. So I know we've had a lot going on this morning. Do you want to address this tomorrow? When do you want to address whether experts should be present?
If I can address it tomorrow morning, I can consider
All right.
it.
We'll do that. And have you talked about who you all mean? Like, do you all know who you want to have exempt from the sequestration order?
We haven't got to that detail. I'm sure they have in mind who they want. I haven't gotten to that point yet.
All right.
We can have that discussion and so that we can present it tomorrow what my position is and address the court on the witnesses.
Sure, we can do that. And then I know you said that you've got an agreement that you'll provide witnesses or a list of witnesses in advance to defense counsel, and I'm sure you'll provide witnesses in advance to Mr. Brennan. Include me on that, please. I just like to know who's coming up the next day because I have to prepare as well.
Happy to. Thank you.
Okay? All right, so we'll see you tomorrow morning.
Thank you again.
All rise.
Only fan, only fan, only fan.
Love you, Linda. Love you. The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
And welcome to Justice Served TV. We are on the air of sorts. Hi, Linda Kenny Bodden. Michael Bryant here.
Hi, Michael Bryan. I feel like we just finished at 4 o'clock. Or
I know you did. I was definitely, lurking, as they say. But you were on and
all day,
and back
all
and
day.
forth. Yeah, good for you.
Since 10 this morning, about 10 this morning. Can't do that every day, but today was kind of an interesting day. I kind of got sucked in, and then of course, my work is still sitting over here. So I have to go.
Yeah, that's what the late night hours are for.
Yeah.
So we got a whole 5 witnesses. I'm not even sure, the last witness for the day, Mr. Whitley, is he done? I don't know if he's done because the day ended on a sidebar relating to a cross-examination question.
Right.
I don't know.
The judge said she was going to rule tomorrow, and it's something that Yanetti's fighting for as to whether the statement, all these statements after years now are just out of nowhere. Poof, they're appearing,
Well, I've noticed
magic.
I've only been up there at Dedham 6 times. Tomorrow will be 7, etc. I remember things I don't remember since I was a kid. I mean, things are just coming back to me, flooding back to me. It's just being up there in that area. Your memory, as time passes, gets so much better. It's amazing.
And it's amazing how it's only better for the prosecution. All these little snarky things become for the prosecution. Although Today, we did have a very interesting witness that we're going to talk about, because I want to talk about, I know you want to talk about the witness, I want to talk about why Judge Beverly Cannoni is not gravely concerned with some of the testimony today that came from the prosecution.
So she was not gravely concerned.
Yeah,
no,
that she was not gravely concerned, right?
No. Now, what's the big deal if somebody changes their testimony, lies to the grand jury? Come on, get over it. What's wrong with you?
Right. Why should you have an affirmative duty, prosecution, to come forward and have it corrected? That should be grave concerns, but we'll get into that. I was so, as I said, being there for so many hours, I now understand why people are so upset about this case, because it's not just the case.
No, it's definitely the symptom of the bigger disease. So just to recap, we're on whopping day number 2. We've had 5 witnesses, or at least up through 5. We've had 1 paramedic, Mr. Nutberger. We had Kerry Roberts, who we're going to focus on today. She began yesterday, finished today, and finished with a zing because it was primarily cross-examination. And then Nicholas Garino. Explain, let's open up the Justice Through TV classroom. Explain why Nicholas Garino, who is a Mass State Police guy who's the digital forensic expert, why we really just heard how wonderful he is at his job and then he was excused.
Because I don't know, there must have been something that they wanted to get into, that the prosecution wants to get into in terms of introducing some text, but they don't want to introduce all his testimony for cross-examination right now. And apparently the defense agreed. So, yeah. I mean, that's what I assume, that there has to be something related to, him grabbing the phones and support. Remember, he took the phones and there was testimony from the witnesses that we heard that the phones were given to him. So maybe that just supports the witness's testimony.
Yeah, some foundational information that has to play out with other witnesses before he comes back for the substance of his Cellbrite.
But everybody on the chat was like,
"You're like, what the hell is this?"
We're going to get to see Alessi. They were like, it's Alessi. People were running their computer. And they were like, that's it?
Yeah. And I think he did object. I think Alessi did object once or twice during the direct exam.
He's going to be fine.
He'll get his chance. But that, I just think a lot of people would look at that and go, what the hell is that about? And so
I think it was just a counter. It was just to bolster the fact that the cell phones were taken, as the other witnesses said they were.
Yeah. So let's see other little tidbits before we get into the Kerry Roberts testimony, which is really the thrust of today. We thought we'd do these nightly recaps because it just seems to be more appropriate just to grab the stuff that's important, even if we just zoom through testimony and focus on it, rather than let it just kind of lie at the end of the given day. And obviously Kerry Roberts was key to today. She touched on so many things. She is a key witness. I think she's a bigger witness in round 2 than round 1 for the reasons we're going to talk about. But before we get to that, in the trifecta of federal cases that have been filed in the buffer zone, I'll call them the buffer zone cases, we know that the protesters had their temporary restraining order denied. That has gone up on appeal. The reporter,
that's the protesters who carrying the signs against Cannoni but weren't saying anything.
Yes, we hate Judge C, is basically the thrust of their protest. Then the journalist with Tom, CPU, and I, that was the second case filed. We also sought a TRO, and the judge did nothing. Remember, there are 3 cases, 3 judges. The third case, Mr. Delgado, the guy that had his sticker ripped off, separate case. 3 judges, 3 separate cases. So ours in case number 2, we filed a TRO. Judge did nothing. Pocket veto, as I call it. Nothing. So we tried to join in the amicus. I like to say amicus. Sometimes I'll say amicus. How do you say it?
Amicus.
Amicus? Yeah, it's one of those. I will say it either way because neither one is cemented in my brain as the right way. I'll have to check it out. Anyway, this brief would allow us to tag along with the protesters' current appeal, which is now being reviewed. The federal district court said no. That's on appeal. And then the state, who are the defendants in these cases, they filed a motion to stay our case while this number 1 case and the TRO issue is pending. We oppose that. We want to force our judge, it's a woman, I can't remember her name, I apologize, but we want her to do her job and rule. But they're basically sitting back and saying, no, let's follow what happens in case number 1 with the protesters. So we are stayed from doing anything until May 14th. Won't affect what happens on the ground there, but just procedurally, that's where we are. We're not getting any relief until at least May 14th. It could be sooner if the appellate court on the protester case, if they rule before the 14th. The reason that the stay was put in place to May 14th is because briefs are due May 10th. And so they're giving 10 days past the date of the briefings to give that court a chance to come to a decision. And then we'll see. We'll see how it all shakes out and trickles down to us poor little, reporter case. It's number 2 on the list.
Well, I think if you get arrested for being in the buffer zone
I wonder
while you're
how that
there
would impact
tomorrow
you.
or Friday, that could be an interesting issue, right?
Well, I do know that Mark
there was
Randazza,
somebody.
our attorney, there was somebody arrested, Boa, and it was like Cher, just one name, I'm not sure. Yes, Boa was arrested, and if you haven't seen that video, you should check it out because it's outrageous. But Mark Randazza, our attorney, has already suggested the need to amend our complaints if, in fact, something does happen when Tom and I are operating in our news gathering capacity. So
Right.
we'll see. I got some new
I-
toys to help with
you
my
have
news
more?
gathering. I got
Okay,
this
let's
ready to
see.
go. I got that.
That looks like some kind of horrible obstetrical thing.
Okay, just open wide.
And that's
Okay.
explain what that is. You put your
This
iPhone
is- yeah,
on it. It's a gimbal.
Yeah, this is I always forget what it's called. It's not an Omni, but it's basically a gyro. You put your thingy on here. You put your thingy on. That's a technical term, your thingy. Put that right on here like that. There we go. And then when you turn it on, it gets all gyro-y, and you can go from vertical like that, or with a quick click, you go like that.
Okay.
And basically, it gives you a little more smooth operation of your news gathering operation. And even better, I can plug the mic into here, and so we get some
Oh, that's even
pretty
better. That's
decent
better.
sound.
Right.
Yeah. So
That is even better. That's terrific. I wish you had your holographic sticker that said Justice Served TV. that
I
you
know.
Put
I
on
don't.
it though, that you could buy at our
I
merchandise
should get
store.
one.
Yeah, because really, I mean, that's what they're there for.
I
if
do
you
have.
don't-
Hold on. I do have. These are not quite as good, but I do have like that. I can put that on there, right?
Yeah, absolutely. You should. I think you should at least put that on.
I mean,
yeah.
it's got our pictures on the bottom. See that?
There you are. There you are.
And there you are. Yes. Okay. That's a good idea.
Well, I won't be arrested with you. I'll be playing poker.
Yeah. Yeah. Don't worry. I won't bother you. Yeah, I'm going to put that right on there. Okay. Anyway, so we'll see what happens with that whole thing tomorrow. It'll be midday before I get there, so who knows? They may not care. I will say that the BOA arrest, I'll call it, happened at the time the parties were arriving. So I'm assuming that when they arrive and when they leave, they tighten things up.
Right.
Don't know. Just my speculation.
Probably that's the case. I did see that you're allowed to go up to the buffer zone until 8 a.m. in the morning. I guess that's when people start arriving, and then they started enforcing it. So because they had pictures of people who are expressing their First Amendment in the buffer zone until 8 a.m. and then they have to leave. So, but the question is, it's so ridiculous because you could have. I was thinking about this. You could have like. I don't have it, but a long range camera, right? Like the sports people use, be sitting down there at the buffer and still get the same picture you get if you have an iPhone and you're sitting, 10 feet away.
Well, I think, and I've given them the benefit of the doubt. I don't agree with them, but I think their concern is bodies, flooding that area, causing some sort of concern for the players. If you're distant enough, I don't think they're trying to protect that. In theory, if you had a drone, which they would probably shoot down, you're not going to be impeding them. So I get a little bit of that. I just think it has to be more properly controlled. So we'll find out because I'll definitely be there tomorrow when they're leaving.
Right.
And that's when I would be wanting to get some video and throw out a question, right?
Right. And see if we can get an interview, perhaps with one of the, we can't get an interview, right? Because they're under a gag order.
No, just Karen Reed.
Just
I thought
Karen
somebody
Reed.
said she did an interview with one of the, I think it was a Boston station. Have you heard that? A new interview?
No, I haven't because I've been busy trying to keep
I've-
covering this and trying to get my own work done and all. But we're going to be on the air about 1 o'clock tomorrow. You'll definitely be on the air checking it out. I hope to join you there. I'll be traveling on the roadways from about 10. I should be stationary to be. So we're trying to get it so that we can start. We'll be streaming, actually. Missy's going to be streaming what's going on tomorrow morning. And then
I think
we'll listen.
And I'll join again, depending on the timing of everything, both tomorrow during the break and then Friday morning, either live from the scene with, our Justice Served mobile unit,
right?
Or I'll be planted somewhere near the courthouse. I know I cannot park in the buffer zone. They definitely will not
Right.
allow
Oh, yes,
that.
yeah. So, but we're going to be on there anyhow. So Missy's going to be streaming starting at I guess 9. She'll be streaming. She doesn't have to be there. I mean, hopefully she can stream and not have to sit at her desk all day. We'll get on at 1 to answer questions, and then we'll see what kind of video and what you're going to gather. Until 4 o'clock, I gather. We'll see what happens at the end.
Yeah, and then again on scheduling, Friday's been back and forth because now the ARCA experts who are going to be voir dired to some degree to satisfy the court about whatever concerns she has. That was going to happen Friday, but to one of them, I can't remember, Wolf or Rentschler, not available. That's been pushed to Monday, so they're going to have a half day on Friday, and there's been no more talk of a view, which was originally scheduled for Friday. So they're just doing a half day on Friday. So we'll be up there for that. And then I've got Miss Shorty who will be joining. We may just end up doing an end of day, midday. We'll see how it
You'll
goes.
see what it is. Yep, see what goes on. I won't feel as bad than leaving you, but you're in good hands with Lisa Shorty.
Oh yeah, I'm not bothered. I'm not worried. Yeah. May you have. I feel lucky to have her. May you have as much luck playing poker.
Yeah, I play these games, as everyone knows, not for money, during the week, with friends, and me and 88 of my closest women friends came in second the other night, and then last night with a bunch of lawyers from Washington D.C. Again, it was just for bragging rights. I came in first, so I'm feeling good about playing in a tournament Friday. I just
good.
tuned up.
Yeah. Let's dive into the cross-examination here of Ms. Roberts. And for those who can't remember, she's a good friend, seemingly better friend of Jen McCabe than she was last trial, but because they've bonded over this traumatic event and the 8 bazillion phone calls and meetings since that time. And again, she is a proud graduate of the Jen McCabe School of Witness Preparation. I believe she got about a B. There are a couple of things she didn't do as well as she might have. But she was definitely prepped. And we have the cross, which of course is critical and most critical of any witness. I don't care who's proffering that witness, but the cross is always where you get the truth. Is that right? Am I right about that?
Well, it's certainly where you can suss things out from the direct as whether they were truthful. And this was a big suss. Remember, she was not cross-examined in the first trial.
Good morning, Ms. Roberts. How are you?
Good morning.
Under questioning by Mr. Brennan, you talked about the number of times or a number of times that you have spoken to the DA's office or some member of the DA's office. I'd like to ask you a couple of questions about that.
Sure.
How many times in total do you think you've spoken to a representative of the district attorney's office?
I don't have a number.
Would you say it's more than a dozen?
Yes.
Would you say it's more than 50?
Maybe around there.
Okay.
Maybe.
Okay, hold it. 50 times? 50?
50.
It's been roughly a year since the beginning of the first trial. I did a little math. 50 times spread out over the course. That's like every 9.2 days. Every 9.2 days, you're talking to somebody from. That's unbelievable to me. I'm sorry.
And I'll bet you there aren't 50 reports, but
Of course.
Less.
And who are the folks, Ms. Roberts, that you have spoken to at the DA's office?
Steve Nelson,
Okay.
the victim advocate, Yuri Buchanan, who's a state police officer, and the DA, Michael Morrissey.
And what was the, I want to take those in order, and 2 of those are at the DA's office. 1 of those is not. Yuri Buchanan is not at the DA's office. He's actually a Massachusetts state police officer. Is that right?
Yes.
Okay. Let's take those in order. How many times would you say you've spoken to Mr. Nelson? Just if you can give me a thumbnail.
I don't know, maybe 30, 40.
Okay. Have you received what you would consider to be updates on the progress of the case?
I would ask questions and he would give me very broad answers.
Okay. Were your questions ever prompted by conversations that you had with your friend, Miss McCabe, Jen McCabe?
Sometimes Jen would say, could you ask Steve this? Because I had a rapport with Steve.
Okay. Were those conversations by text message or phone calls or both?
I would usually text him.
Okay.
Stop.
What about...
Hold on. We got a text. Yes, text.
I wonder if all those texts have been turned over.
Yeah, where are they?
I wonder if every single text has been turned over. Okay.
I wish I knew that as well, because they should be. You know that she's got to have some sort of ethical obligation as a human being.
The conversation with, or conversations with Mr. Morrissey, the elected district attorney, what were the circumstances under which you contacted Mr. Morrissey?
Well, during the course of this trial, the witnesses have been harassed.
That's not my question.
Objection.
But I'm answering your question.
Hold on. I'm going to sustain the objection. Next question.
Thank you. Were you phoning him? Were you meeting him? Were you texting him? That's my question. The circumstances of the communication itself.
I phoned the office asking for a meeting, had a meeting, and then he left a voicemail at some point and texted me and said, I just left you a voicemail.
Okay. Was that the extent of your conversations with Mr. Morrissey, the elected DA?
I had one other meeting with other witnesses.
Okay.
And the DA.
And turning to Yuri Buknik, what were the logistics? I'll use that word instead of circumstances. What were the logistics of you contacting Yuri Buknik? Was it by phone? Was it in-person meetings, text messages, or all of the above? All of the above.
All of the above.
How many times would you say that you've spoken with Yuri Buknik?
Spoken or communicated?
Sorry, good point. Communicated with?
Probably 20.
Okay. When was the last time, actually, let me ask you a different question. Have you ever met with Mr. Brennan before your testimony today?
Yes.
What was the circumstance of that meeting?
Going over my testimony from the last trial.
Okay.
And sort of just asking questions on what might come this time. Would I be cross-examined? I wasn't last time. Just sort of, all the things went through my testimony.
Okay. When was that meeting?
I don't know, in the last couple of weeks. I don't know.
Okay. Where was the meeting?
At the DA's office.
Who else was there?
Different times that I would meet with him. Steve Nelson would be there. One time, Brian Tully was there. Mr. Brennan's assistant.
I'm sorry?
Mr. Brennan's assistant.
Okay.
I don't know. Adam Lally and Laura McLaughlin.
Were those meetings, you said there was 2 meetings? Or did I misunderstand you?
Yeah, I think there were 2.
Okay. Were those close in time to one another? You mentioned 2 weeks ago. Were those both 2
I
weeks?
said a few weeks ago, but the other meeting was just before I was going to testify.
Meaning, what, yesterday, the day before?
Last week.
Was that also at the DA's office?
Yes, it was.
Were you shown anything at that meeting?
Was I shown anything?
Videos, testimony, transcripts?
No.
Reports?
No.
Nothing?
I don't think so.
Okay.
We went over my testimony on the screen. And then I just talked about my testimony from the last time.
Okay, so imagine this gathering, right? All of the prosecution team, for the most part, and they're going over her video direct examination, all that she provided in trial 1, and they're fixing her. They're telling her what to anticipate in cross-examination, right?
Right.
Having seen her during cross-examination, I'm not so sure they got her really prepared for what was to come.
Well, the problem I have is that you're now setting the stage for all these people there who are talking about her cross-examination. Somebody had to anticipate about the answers in front of the grand jury we're going to hear about.
You would think.
And no one has apparently corrected the record before she got on the stand.
And one thing that makes your point is that you don't have an answer for a clear, blatant lie that sounds like, I guess I misunderstood the question. That is a prepared, coached answer. That is not something you come up with on your own. As an aside, I heard Judge Bev, after somebody objected, did you hear her catch herself? She said, what are the grounds for the objection?
Right.
She caught herself because her dumb rule won't allow it.
Right.
Okay. When you say you went over your testimony on screen, what do you mean?
We watched my testimony from the first trial on a TV screen.
Okay, so you were shown something. You were shown a video of your prior testimony.
Yes.
So I'd like to see counsel at sidebar for just a minute, please.
Just as Alan gets going, she interrupts him.
She interrupts him. You have to assume that has something to do with some guardrails they've put up about talking about the first trial. What's your speculation?
That's whatever they are, guardrails, whatever they are. But I really want to. How could you put up guardrails if somebody is going to admit to telling a falsehood, or as Alan would say, that was false, that was a lie, and we're going to hear what was a lie. It's pretty important.
Yeah. Okay. So post sidebar. You see, this is Alan setting up this video clip.
But Alan really worked hard on this cross-examination.
May I?
Yes.
Thank you. Other than watching your testimony, were you shown anything else? Transcripts, videos that you may have seen today, dash cam videos, anything like that?
I don't think so.
Okay.
I don't think I was shown anything.
Okay. Did you discuss other parts of your prior testimony?
Yes.
Okay. What was discussed concerning your prior testimony and how it would impact how you testify today on direct examination?
Mr. Brennan had just asked me, can you just tell me what happened? So I told him the story verbally.
Okay. Anything come up about specific instances of how you were going to testify today?
No.
Or yesterday?
No.
Okay. I want to talk to you a little bit, Ms. Roberts, about the video that you were shown by Mr. Brennan. It's the dash cam video of Officer Seraph. I'm not sure if you know which officer that is.
No, I don't.
It's the one that you've been watching.
Okay.
That dash cam that shows your car in the foreground.
Yep.
I'd like to ask you a couple of quick questions about your memory of that incident, and then perhaps show you the video depending upon what the answer is.
Sure.
Do you remember when the officer first arrived, you and Miss Reed specifically were at Mr. O'Keefe's body?
Yes.
Where was Miss McCabe at that moment?
She was there too, but she was waving down the first responders because it was dark out and he couldn't see us. He had a spotlight.
You and Miss Reed were both providing some level of CPR, some level of life-saving efforts.
Yes, as was Miss McCabe.
What was Miss McCabe doing?
When I was doing chest compressions and Karen was doing mouth-to-mouth, Jen was either on the phone with 911 or handing me baby blankets.
Okay.
At some point, she did take over doing chest compressions because I asked her to.
Okay. So Miss Reed was focused on Mr. O'Keefe's head, face area.
Correct.
You were focused on the chest.
Correct.
Miss McCabe was, at some point at least, she had called 911 or dialed 911.
Yes.
When Miss McCabe dialed 911 and was on the phone with 911, isn't it true that she was actually in a vehicle at the time?
That is not true.
She was outside?
She was outside.
That's your memory?
Yes.
Okay. Have you heard the 911 tape of that call?
Yes.
Okay. You're aware that that tape was also captured by an open line on Miss Reed's phone?
Yes.
That open line that phone was dropped inside the cab of an SUV?
It was in the back seat, I believe.
Right. So in order for that for that open line to capture sort of the background of Miss McCabe's side of the 911 call, Miss McCabe would have had to have been either at or in the cab of the truck?
The back of the SUV was open. She was standing there.
Got it. Okay, so she was right next to or adjacent to the cab of the SUV.
She was in back of it with the back was up.
I see, that back hatch?
Yes.
Okay. Do you remember Miss Reed's statement, her initial statement to Officer Seraph when he got out of his patrol
I do
car?
not.
Do you remember her saying something to the effect of, "My boyfriend, I left him, he never came home"?
I do not.
Okay. Have you listened with audio to that dash cam at the moment that Officer Seraph arrives at the scene and y'all flag him down?
We just watched it.
Right. Have you listened to it for the audio side? I mean, in other words, instead of focusing on the
no.
video.
No.
Okay. I'd like to ask you to do that with the court's permission. This is it's been previously marked as Exhibit 4. And with the court's permission, I'd like to play that from runtime about 3:50 and ask the witness to concentrate most readily at about 4:07, maybe 10 seconds into it. I'm going to give a little run up and then ask you to listen very closely to the audio.
Yep.
This was far less effective than I thought it would be.
Okay, Evan. Stop. Do you recognize the video as being the same video that you saw and you looked at on direct examination?
Yes.
Okay. In just a quick second, the door to the car, you're going to hear it open. I'd like to ask you to pay special attention to the audio portion and Miss Reed's voice.
Okay.
If you can hear it. Go ahead. Stop. Did you hear that last statement?
No.
Did you hear a woman's voice kind of faint in the background?
I heard a voice, but I didn't make out what she was saying.
Okay. Did it sound like she said, my boyfriend, I dropped him off and he never came home?
Objection.
Could you hear that, Ms. Roberts?
No.
Okay.
Next question.
That's all I have for the video. We can take that down. You talked about, on direct examination, some of the injuries that you saw Mr. O'Keefe having suffered, both what you observed at the scene and then what you observed later at the hospital.
Yep.
And speaking of injuries, Michael Brown, why don't
And
we
you noted
stop
those
this?
injuries.
Yep, that's
Why
a good
don't we
idea.
stop this right now? And I'm going to tell the people that are watching that we're going to get to the prevarication, the admission that there is a misrepresentation to the grand jury. Some will call it a lie, and all in a bit. And we're going to build up to it because we're going to stop at injuries because we have a very special guest with us who's not going to talk about this case specifically. But Chris Fabricant is the person who knows more about bite mark evidence, also called forensic odontology, probably in the world. All right, he's written a great book called Junk Science. You can get it on all sorts of any place, Amazon, wherever you look it up. We put it. I think we put it on our website, on our little YouTube streaming site. And also, he does know that the setup to this was that the prosecution wanted to do dental molds on a German Shepherd who has aged several years to show that even if these marks on the decedents in the hands, in this case, arms and hands, in this case, were from a German Shepherd, that they can tell through dog forensic odontology that this German Shepherd is specifically excluded by measurement. So I just want to have Chris Fabricant, give him a big welcome. He's going to be professorial, and he's going to talk to you about forensic odontology generally and why it's junk science. Now, you can differentiate a dog bite from a something else, from a whack or whatever. But that's not what we're talking here. Welcome, Chris.
Hey, Chris.
Thanks for having me. Yeah, it's all hogwash, and I'm not convinced that you could differentiate between a dog bite and some other bites. So even at that threshold level.
That's really interesting on it. But tell us about forensic odontology. You have, in your work with the Innocence Project, you have obviously are responsible for getting a lot of people out of prison who have actually gotten the death penalty for bite mark evidence. You and also my friend who's now a judge, Chris Plord, in San Diego, was one of the forefront leaders in this. But you really have been the leader in taking it to the courts. Where does it stand? And why would a prosecutor, knowing all this, try to use dog forensic odontology these days?
Prosecutors will, introduce whatever the judges and the courts will allow, and sadly, forensic odontology is still allowed by many, many courts around the country. With that said, though, last summer, Justice Sotomayor said in a published opinion, and a concurring opinion in one of my cases, Charles McCory out of Alabama, that, this evidence has been entirely discredited, and I have 3 clients on death row right now, all put there through bite mark evidence. And there have been nearly 40 wrongful convictions and indictments attributable to the use of, so-called bite mark evidence. And really what you think about is that trying to interpret an injury on skin, particularly in a homicide case, is that what the forensic dentist or the forensic pathologist or whomever it is that's going to come in and take a look at this evidence is going to do it long after these injuries were inflicted. So skin is an ever-changing medium, right? If somebody who's like matches one day, might not match the next day, hour to hour, day to day, week to week, they're just capturing a moment in time that's going to be constantly changing. And you don't know the way that the arm was held when it was actually inflicted. So you think about it, like the dog bit, like, or a person bit when the injury was like this, and then you take the photograph when the arm is extended, it's going to look completely different. So this is always just kind of gross speculation. And having competing experts in this type of case is just like two people arguing about how flat the earth is.
Wow. It seems to be that they must have had absolutely no DNA from a bite, because that would be so much easier and better.
I mean, even like the forensic dentists will tell you, even the last of the Mohicans that are still like holding on to this last shreds of this totally discredited technique will tell you, all of them will tell you, number one, swab it for DNA evidence, right? Because DNA evidence is a real science, unlike the voodoo of forensic odontology. So I have been getting a lot of emails about the Karen Reed trial because they're like, hey, Fabricant, do you know that they're trying to bring this in this trial and it's a dog bite evidence? And then I looked at it and I was like, that they literally took a dentition of a dog where there's no database. You know what I mean? Like what the evidence shows, right? The forensic dentists who actually look at this stuff and day after day, week after week, they cannot reliably diagnose an injury as a bite mark, period, right? To say nothing of associating with anybody. So the idea that some expert could say that, oh, this was made by these teeth or that teeth is crazy, because you can't even say that what instrument was actually used to create the injury.
Interesting, because the judge did say to the prosecution, you do have an uphill road to get the fact that these teeth are specific to Chloe, the German Shepherd, in this case. That's just, so talk to us about the fact about the specificity where anyone's trying to get specific to a specific, where you may be able to say it's dog bite, but specific through measurements of forensic odontology.
Again, I don't think that you could even say definitively that it's a dog bite. You know what I mean? What you had, like they did a Daubert hearing in this case, right? And if you think about what's required for a Daubert hearing, right? One is testability, right? Somebody claims that that's a dog bite. How are we supposed to falsify that? We have no idea. We're just going to have to take your word for it. Okay, well, let's take your word for it. You're supposed to have an error rate, right? So how often do you get it right? And how often do you get it wrong when you claim something is a dog bite as compared to something else? No idea, right? So it's not a testable hypothesis. We don't know what error rates are. There is no peer-reviewed literature, not any real literature. There are some people that have written a little bit about this. It's totally rejected by the scientific community, and it's not maintained by any standards whatsoever, right? So it flunks every single one of the Daubert tests. So I was shocked that it was going to be let in at all.
Oh, yeah. Yeah. And we're not even factoring in dogs who have an Invisalign and they correct their bite over time. So what about, I'm sure in all of your experience studying, reporting on, analyzing dog bites, the victim always stands perfectly still so that the dog can make the best impression on the wound, right?
Right. This is the point that I was making earlier, is that, bites of any kind, from be it dog or human, is inflicted almost always during a violent struggle where, I think a lot of your viewers, you'd be thinking that they have an idea of what a bite mark looks like in their mind because they have toddlers that come home from daycare and say, Johnny bit me, right? And it looks like a bite, right? But that's never the way they look in casework. It looks like in this Karen Reed case. You could say like one person saying it's from a car, another saying it from a dog. Who's to say who's right? Without DNA evidence, it's all speculation. There's no expert witness testimony that is going to advance this idea, right? Because the search for the truth is never advanced through junk science.
Right. As a matter of fact, as one of our mods points out, though, there was no Daubert hearing for Dr. Crosby, that's the Commonwealth expert, who took the dog bite impressions, and he's not even a forensic dentist. Let's even get to that level. He's like somebody who trains dogs. A former police officer trains dogs.
What is it about somebody that's a dentist, though, really, or a dog trainer, that would have any expertise on interpreting an injury on skin. None, zero. What is the proximity to teeth, the proximity to dogs? It's crazy. You're just claiming this expertise because it's like, I'm near dogs. I know what dogs look like. I've seen a lot of dog bites. That's nonsense. It's the same kind of expertise that dentists were claiming. And it was just like, what is it about doing root canals that makes you an expert at examining a bite mark? Nothing, right? You're being hoodwinked.
Interesting. The whole thing is interesting. So the clients that you have now on death row, where do their cases stand with bite mark evidence?
Well, we have Jimmy Chris Duncan is on death row in Angola, one of the most notorious, outrageous prisons in the United States in Louisiana. It's literally a former slave plantation. And right now, today, there are white men on horseback with shotguns overseeing black men in chains picking cotton, you know what I mean, right now, you know what I mean, in Louisiana. So he's there on bite mark evidence that was created by the notorious Dr. West and a forensic pathologist that was also equally notorious named Stephen Hain, who put him on death row, and he's been there for over 30 years. We have a client in Ohio, Danny Lee Hills, put there by bite mark evidence. And we have Jimmy Rogers in Georgia, all of whom were, whose cases relied on bite mark evidence. You know, and I've been personally involved in 10 exonerations involving people that were put there through bite mark evidence, you know, and Charles McCory, the innocent man in Alabama who's serving life without parole, was the case that Justice Sotomayor wrote about, you know, last summer. So we're still fighting for, you know, his freedom in federal court right now. So, you know, you can see the legacy of junk science. What I worry about in a case like Karen Reed's or any of these cases that are very high profile, if you look at it, a case that you're familiar with, Linda, you know, I mean, is the Casey Anthony case, right?
Right.
Is like in this very high profile case, they were managed to get in despite a very well litigated case by you, is that the smell of death, right? And that was allowed into evidence as scientific evidence, which is total nonsense.
Right,
Still today, total nonsense, but now it's part of case law. So courts will still use it,
right?
Even though there's no scientific backing.
Yeah.
So you get a case like this, you know, and there is like Mr. Shifazari, is in Massachusetts, spent 37 years in prison for a crime he didn't commit in Massachusetts. That was done entirely by bite mark evidence by Dick Souveron, right? The same guy who testified in the Ted Bundy case. So
is he out? Is he out, the man in Massachusetts?
Yeah.
He's out, right? That's recently. He's one of your clients recently exonerated, I guess, in the past 2 years, I think, if I recall.
Yeah, it was the New England Innocence Project that did that. I was not involved in that case, but he was an innocent man, wrongfully convicted through bite mark evidence. And, you know, what I worry about in a case like this, you know, I mean, is that, you know, where they're going to allow in some sort of dog bite evidence, and we're going to create legal precedent that where people aren't watching the same way that they're watching the Karen Reed case, you know, and it's going to sneak into court because it's been introduced before now, and it'll wrongfully convict somebody.
This, I think, is a different twist on things, Chris. Give me your take on this. Here we have the defense proponent that is going to be arguing that it is bite mark, and in fact has forced the prosecution to come up with their own expert that got it by doing a couple of seminars on YouTube, I think. Right. But differently, and then it's not a prosecutor trying to pin a bite on a defendant. It's the defendant using it to come up with a different cause of the injuries to the victim.
Well, the ethics are a lot different because a defense attorney is ethically required to defend their client as zealously as the law will allow. And the law is allowing this, you know, so I'm not faulting the defense for doing their constitutionally obligated duty. What I'm faulting is the courts for allowing subjective speculation masquerading as scientific evidence in front of a jury, you know, so I, you know,
even to entertain the issue of whether or not a mold was going to be allowed, a mold of a denture of a dog. I mean, that to me, that was like out of control.
It's crazy. Yeah. I mean, what the prosecution was trying to do is totally bananas. You know, I mean, you can imagine, you know, as a, you know, there's no expertise that is being used in this case that will advance the search for the truth. There just isn't, because there's no evidence that these experts can do what they claim to be able to do.
That's interesting. So that's the real ethical issue. Of course, you really shine the light on this. I'm going to have everyone look up the New England case. Could you say the name again? So our
Shifazari is Chifazari, ARRIZI, something like that. I'm probably not getting it
Find
perfect, but it's in the
Got to be
ballpark.
close.
Yeah.
Yeah.
It's in your book. And your book's name again?
Junk Science in the American Criminal Justice System.
Thank
Beautiful.
you.
Such interesting stuff, man. It's no matter how it's used, it is fascinating. And I guess it's only time before we see if somebody's going to take a stand against this and maybe hopefully put you out of business.
That's what I'm here for, right?
Yeah.
You know, it's fascinating the way that a car accident is fascinating.
Yeah. Thank you, Chris. Chris
Thanks,
Fabricant,
Here, sir.
really a hero, getting all these people that were wrongfully convicted out of prison. Very, very interesting analysis. I mean, the analysis is that he thinks that dog bite evidence is junk science, period.
Yeah,
And
no matter who's using it. But I'm envisioning the theater of the prosecution with their mold, their
Oh, that's
Chloe
me too.
mold. Oh my
Right.
God. I'm all for props. I'm all for demonstrative stuff. I think it's going to be powerful, and it's going to take a lot to totally negate it in front of the jury.
No, that's what I'm concerned about too, because I think you can easily say, the forensic pathologist can easily say that the car didn't cause the injuries on John O'Keefe because he didn't have any injuries in the front of him. That's easy. So the question becomes, what could be the alternative? The defense has an alternative theory, but then the prosecution goes out and wants to take this complete junk science of putting moles on people's teeth to the exclusion of all other animals in the
And
universe.
so it's really a fascinating wrinkle in this part 2 to this case, because some jurors may say, they're sure fighting hard to prove that Chloe didn't do that. And, they've given, by doing their mold, they've given some credit to identifying a dog bite on somebody, right?
Right.
And I mentioned it earlier during some of the live testimony that I'm not so sure that doesn't backfire on the prosecution.
I agree with you. But I think we have a duty here at Justice Serve TV to bring you what the real science is, what junk science is. As we said, we take no stands except for the stand for the truth. And that's what's happening out there in the real world, that people are getting put in death row for this whole idea that you can have a mold, a dental mold, and then measure a wound, from humans to humans, then put somebody in jail to the exclusion of everybody else in the world.
Yeah, that you have to imagine that is a Hail Mary prosecution move, and it's scary how often it seems to work.
Yep, that's concerning.
Yikes. Okay,
Yikes.
so let's see
Okay.
if I can get back into this, if I can hit the right button, because you know me, it's a crapshoot.
Yeah, I'd love to find where she talks about her grand jury, obviously.
Okay, well, let's see. Let me do this.
Right?
Say it again?
You noted those injuries. Those were
Yes.
You made note of those.
Yes.
Or at least some of them. You said that you saw a hematoma of some sort over his right eye. Is that right?
Correct.
And there was some significant swelling to his right eye?
Correct.
At the scene?
Correct.
Did you also notice a laceration just above his right eye, just under the eyebrow?
I saw it at the hospital, but I don't know if at the scene I saw it.
Fair enough. At some point you saw that laceration to his right eye?
Yes, I did.
Did you also see a laceration to the left side of his nose, a smaller laceration to the left side of his nose?
I don't recall. I know there was blood coming from here, but I don't know if it was coming from inside his nose or from a laceration. I don't know.
When you said here, you're pointing to the left side of your nostril.
Yes.
And basically just above the nostril, correct?
Yes, right around the nostril, there was blood coming this way.
Okay, draining to the left side of his cheek?
Yes.
Okay. You also saw, once you got to the hospital, that his left eye had swollen as well.
Now, both eyes were swollen and filled with what looked like blood.
And his left eye was black as well as his right eye?
Correct.
Okay. You also indicated that you saw, well, actually, I don't know if you did or not, so I don't want to put words in your mouth. I apologize. Did you see his right arm?
I did.
Did it appear to you that he had some abrasions or lacerations, parallel abrasions and lacerations and punctures on his right arm?
They were scratches.
Scratches. Ms. Roberts, you've previously testified that when you arrived, let me take you back instead of jumping right into it. After you met up with Ms. Reed at Jen McCabe's house that morning, so this is just after 5 o'clock or so, the three of you arrived back at One Meadows, correct? Is that right? I'm sorry.
Correct.
Okay. You're trailing the Lexus SUV, correct?
Correct.
The Lexus pulls in to the driveway and you pull in directly behind Miss Reed and Jennifer McCabe is driving.
Correct.
You're driving your SUV, correct?
Correct.
You've previously testified that when you arrived at One Meadows at that moment, that once that SUV, the Lexus SUV, had pulled in and you pulled in behind the Lexus, you got out of the Lexus, sorry, you got out of your SUV, they got out of the Lexus, and that's a point at which Karen showed you the back of her taillight and said something to the effect of, do you think I hit him? Do you think I hit him? Oh my God, do you think I hit him? Do you recall that?
I recall saying I didn't know if it was when we were coming or going, but she did point out the taillight.
Okay. When you previously testified under oath, your quote was, quote, Karen pulls in and I pull in behind her.
Mr. Jackson.
It happens a lot.
Get page and line numbers when offering statements.
Sure. It's the SGJ, the grand jury, page 58, lines 14 through 19 for court and counsel.
Okay, now we get to the grand jury stuff.
Did you testify, quote, Karen pulls in and I pull in behind her, period. When we get out, and Karen is now showing us the back of the car saying, my taillight, do you think I hit him? Do you think I hit him? Oh my God, do you guys think I hit him? Question mark. End quote. Is that how you testified?
May I see it?
Sure.
She thinks he's lying when he reads it.
Or she's trying to see a way out of it.
Again, she does a good job at buying time, I will tell you that.
I apologize, I've already got it up here.
Does it have a date on it, Mr. Jackson?
It does. (4/26/22). May I approach?
Yes.
Thank you, sir.
Everything happened in April with this
Thank
case. Just different years.
Do you have the pages after this?
Oh.
I'm sure I do.
Because in the pages after this, I say,
My question, Ms. Roberts, is that a quote that I just said, is that accurate? Do you see it in the?
yes, it is.
Okay. May I approach?
Yes.
Don't get snippy. You can see she's already getting a little annoyed and hasn't really even gotten to the good stuff yet.
Right. Here you are. Thank you very much. Stay from Demonstration Facebook.
Yeah. May I approach?
Yes.
Oh my God, stop fucking lying.
Thank you. Just for reference, I'm going to show you both pages. That's the page I asked you to look at, and then the following page as well. Please take your time.
Okay.
Yeah, we got nothing else to do. Take your time. While she's looking, I will remind folks, if you just joined us, you just missed an amazing interview with a bite expert, right?
Forensic odontology expert. Right?
Yes, that's easier for you to say. So we'll cut that and repost that. It's just fascinating how what he does applies to the.
What I'm looking for is still not here, because I did say I wasn't sure if it was before or after.
Ms. Roberts, you do have to wait for questions.
Okay.
When you gave this testimony, you were in front of a grand jury, correct?
I'm not sure which one that is.
Do you remember testifying in front of a grand jury on April 26, 2022?
Yes.
Okay, about 2 years ago.
Yes.
Sorry, 3 years ago. You were under oath at the time. Is that right?
Yes.
Things were fresher in your mind at that time than they are now, 3.5 years later, I'm guessing, correct?
Yes.
Okay.
Ooh,
you were asked the question to describe the circumstance when you arrived at One Meadows. Is that right?
Yes.
And the answer that you gave was, quote, we pulled into the It's a driveway. There's 2 cars, and then 2 cars, and then a single. So John's car is there. Karen pulls in, and I pull in behind her. When we get out, and Karen is now showing us the back of the back of the car, saying, my taillight, do you think I hit him? Do you think I hit him? Oh my God, do you guys think I hit him? That was your testimony at the time, correct?
Yes.
And just to be clear, I'd like to take a look at a quick video that you may or may not have seen before. We'll find out. Your Honor, I'd like to have this. Actually, this has already been previously marked as Exhibit 12C as in Charlie.
Okay.
And it's a short clip. So I'll play the entire clip with the court's permission.
Okay.
Let's go ahead and take a look at that video.
Remember, the grand jury testimony was roughly 3 months after the incident.
Can you pause? Do you recognize what's depicted in the video?
Yeah, that's when we arrived at John's house.
Okay. And who's the person with the plaid red pants?
That is Jen.
And who's the person that's just rounding the back of the car in front?
That is Karen.
What is the car in front?
That's Karen's SUV.
That's the Lexus SUV.
Yes, it is.
Behind that Lexus SUV, Ms. Roberts, is there another car?
That's my car.
And who's getting out of that car?
I am.
Okay. And this is the point that you were describing in your, at least in the grand jury testimony at that time.
Yes.
This is the time that you're describing.
That I thought it was when we walked in.
This is the time that you were describing, right? When you arrive at the scene.
Yes.
Or, sorry, arrive at One Meadows.
Yes.
Okay. Let's go ahead and play this through. Okay, you can stop it. And you can bring the lights up. You saw the interaction between all 3 of you and the vehicles, correct?
Yep.
At any point, did anybody stop and take a look at the tail light or the rear end of the car?
Not when we were entering the house like I thought, but when we came out.
Okay. And there's no video of that?
I'm sorry?
There's no video of that?
No, I don't believe so.
Right. So the video that does exist describes nearly exactly the time that you testified that y'all stopped at the back of the taillight and Karen said, look, my taillight's broken. Oh my God, do you think I hit him?
Correct.
Right? Okay. And that obviously was incorrect.
It was incorrect.
So your memory was faulty about that incident, that part of that incident at least.
It happened on the way out of the house.
So your memory was faulty about that part of the incident that you testified to at the grand jury?
Yes.
Okay.
This is a brilliant cross-examination, by the way. It takes a lot of time to set it up.
So now the jury's thinking, well,
You
let's see the video.
were interviewed on January 29th. You've already testified to that, correct? By
Yes.
Troopers Dunn and, my memory's failing me now.
There were 2. I don't know who they were.
Okay. I'm sure it's in my notes somewhere. 2 individuals that interviewed you on January 29th, correct?
Yes.
Obviously, things were very, very fresh in your mind at that point.
Yes, but I believe I was in shock, so.
The incident had just happened.
Yes.
Okay. And you were asked to recount certain of the specifics about the incident that you had just experienced, not days or weeks, but just hours before, correct?
Yes.
Okay. And you did your best, I'm sure, Ms. Roberts, to be as full-throated as possible, to provide them with as much detailed information as you could, and to be as honest as you could.
Yes.
I mean, you weren't going to lie to these police officers, right?
No.
A lot of setup here.
Full-throated.
In your very first conversation with those 2 troopers on January 29th, you didn't mention anything about a taillight or a cracked taillight, or
No,
you
I
haven't
did not.
seen a cracked taillight, did you?
No, I did not.
Okay.
I
You
didn't
then-
want to accuse anybody of anything.
You were then interviewed on February 1st, 2022, a few days later, correct?
I don't know.
Does that
I don't
sound
know
right?
the exact date. I was interviewed again, but I don't know the exact date.
Okay. During your interview, let me withdraw that and ask a different question. on February 1st, or whatever day it was, the subsequent time that you were interviewed just a few days later, you did then, for the first time, describe the taillight that you saw, correct?
I don't know.
Would it refresh your recollection if you looked at a report?
Yes, please.
Okay.
Okay, so she looks at the report.
That you were interviewed.
Everybody watches her looking at the report. You have issues too with showing the gallery when they're down moments.
I have big issues showing the gallery, especially when they're done. Big issues.
Did Connor Keefe write that report?
Trooper Kathleen Prince wrote the report.
Okay.
Does that matter? No?
Nope.
Okay. Does that refresh your recollection that you did discuss the taillight at that time?
Yes.
And did you tell Trooper Prince and Trooper Keefe that you noticed the back right taillight in the middle, quote, in the middle, your words, was broken and a piece of the metal encasement was pushed forward?
Yes.
Okay. You didn't say that the taillight was completely shattered, correct?
Correct.
You didn't say that the entire lens was missing, correct?
Correct.
You said it was broken in the middle. Is that
Yes.
right? And then you described today that a square piece was missing.
Yes, that's the piece I was referring to in the middle.
Just in the middle of the taillight, though. That was how you described it.
Yes.
Okay. I'd like to shift gears for a quick second and talk about a March 7th, 2023 text message with victim witness advocate Steve Nelson. Do you remember communicating? You don't have to know the exact date, but if you do, fine. Do you remember communicating in March of 2023 with victim witness advocate Steve Nelson about the Ring camera at One Meadows?
I don't know the exact date, but yes.
Okay. Is it true that you contacted him to inform him that the O'Keefes needed to replace or wanted to replace the driveway Ring camera, that same Ring camera that we just literally saw through that perspective
Yes.
of you arriving?
Yes.
Did Mr. Nelson indicate that he believed that would be fine to replace?
I don't remember if he said it would be fine, but at some point they were told they could replace it. It had broken. It wasn't working.
Did he indicate that he would check with DDA Adam Lally and then get back to you?
I don't know.
At some point, you were informed that the O'Keefes had the green light or the go-ahead to replace that Ring camera at One Meadows. Is that right?
Yes.
Okay. And then ultimately, you then relayed that to the O'Keefes that they had the green light. You've talked to somebody at the DA's office, and they said, yeah, go ahead and replace the camera, correct?
Yes.
Okay. Did you ever receive any kind of response from the DA's office, either before or after you relayed this information to the O'Keefes, to say, wait, hold on, we need to do a reconstruction, we need to make sure that the camera is in the exact same spot that it was at the time of the incident?
No.
Any communication like that?
No.
So the communication that you got was, yep, go ahead and replace it, it's no big deal.
Correct.
Okay. And ultimately, you learned that the O'Keefes did, in fact, replace that Ring camera.
Correct.
You have already described your relationship, at least in part, with Canton Police Officer Sergeant Michael Lang, correct?
Yes.
He is friends with you?
His daughter is friends with my daughter.
You're friendly with the family?
Yes.
Okay. And you're aware that he's also friends with the Albert family?
No, well, no.
Were you aware that Michael Lang grew up with Chris Albert?
I was not.
Have you ever been in a social setting with both the Lanks and the Alberts?
No.
You're aware, obviously, you were at the scene. He was the first officer to respond to the crime scene at 34 Fairview on January 29th after Officer Seraph and after Mulaney arrived. Right? Then it was Sergeant Lang.
I don't know which order. I did see Sergeant Lang there, yes.
Was he the Was he the, excuse me, sorry. I was just reminded, you indicated that you don't remember the date of that text communication between yourself and Mr. Nelson.
No, I don't remember the date.
Would it refresh your recollection if you looked at a text message between the two of you about this, the subject of the Ring camera?
Sure.
Okay.
Do I need to know the date?
May I approach? I need to know the date.
Oh, okay. Sorry.
Okay. I'll tell you what, this incident has done wonders for all the Ring cameras in the area that have either been missing, not working, need to be replaced. It's amazing.
And the Ring cameras at Fairview.
Oh, hey. I just interrupted myself, I think. Michael Bryant here at Dedham. And it seems like every time I'm here, it's either I'm freezing my ass off or I'm roasting. So today is roasting day. Good to have you along. Linda Kenny Bodden was going to join. She's had some things she's got to deal with, so we're going to muddle through without her able assistance. We hope you'll stick around as we do that. You may notice a couple of things. First of all, I'm not in handcuffs, much to Linda Kenny Bodden's chagrin, and I'm pretty darn close to the courthouse, right across the street, because things are done for the day, done. And when that happens, everybody flees. The troopers, everybody. So I'm in my what I call my normal spot. Others in the local media might disagree with that description, but I call it my local spot. So we got a good view of what's going on and a great opportunity to bring you up to speed on what the hell is going on. As I said, they're done for the day. Why are they done for the day? It's Thursday. And, they were supposed to have a full day today, partial day tomorrow, because as you'll recall, the court wants this voir dire of the two ACA experts. That was going to be tomorrow. That pushed the view off of the calendar for tomorrow. That voir dire will be Monday. And so guess what's back on the calendar for tomorrow? The View. And I don't mean the ladies sitting around the table, although that might be entertaining as well. If they were to go there, have the view at the View. But I digress. So that's procedurally, that's where we are, the housekeeping, where we are. As you know, most of today was taken up by the scintillating reading of text messages that took place between Officer John O'Keefe and the defendant, Karen Reed. I don't know, did you find what the prosecution wanted you to find in those? I mean, the most damning thing, if any, that I heard was somebody get whacked with a pillow that morning. Downright domestic violence. So I don't know. I don't know what the jury walks away from that day-long deluge of text back and forth. Is it painting a picture for them of such, relationship discord and upset and anger that it's culminating just hours later with Karen Reed running into either forward or backwards or sideways? I'm not sure what the argument is this time around. Into Officer John O'Keefe, leaving him to die in the snow. Is that the takeaway? I don't know. Not my takeaway. I don't matter. It's the jury, the folks who are in this building behind me. What are they thinking of this back and forth? I get the sense, if I run that jury and I try to sanitize myself with what I know, and since I have short-term memory loss, it's helpful. I'm thinking, where's the bombshell? When's it coming? When am I going to hear something that says to me, whoa, this was a relationship just waiting to explode in violence? I just didn't see that. So we also had some further foundational witnesses of no really important, needed procedurally, not substantively. The C.F. McCarthy bar operator, the Waterfall bar operator. That's because the videos are coming in. We know that they're going to be dissected and micro connected to one another and slowed down and sped up like the Zapruder film. We're going to see all that stuff. To get that stuff in, they did need to lay the foundation by those who are custodians of record. That would be the legal term. They oversee the operation of the video equipment. They maintain it. You may have noticed a question that asked whether somebody outside the bar was involved in the operation or maintenance. No, it's all those hands-on folks. So they're in now. They're in. And thank you so much for the super sticker. And I'm going to just say, Biglet. The light here is brutal. I will be melting at some point in the next hour. I'm not sure when it's going to happen or how, but just be warned. And I should not complain because I've frozen my butt off up here many times. I will take this. I will take this instead. The only thing I'm missing is my golf clubs, because this is perfect golfing weather. So we got those folks in. There was some confusion about this. There will be testimony tomorrow after the view. Not sure exactly how long the day is going to go, who those witnesses might be. I got the impression, I was just pulling in and setting up when the officer, Camerano, was wrapping up. And I couldn't tell if he was really done or not. I got the feeling he was just mid-text, but maybe I missed that. Correct me if I'm wrong. But if he has not finished, I would imagine he'll come back and finish. If he is, then we got some new folks here. I do have a couple of questions that we can get to, but before we do that, I was wandering the streets, and as I mentioned, I'm not in cuffs. So I had with me today all of these things. This is press passes, both current with New York City and others I've had over the years from LA County Sheriff, LA County PD, California Highway Patrol. I'm just thinking, I'll wear this, play their little game, see what happens. And they could not have been nicer, to be honest with you. Doesn't mean I'm not going to continue suing them over what happened on April 1st. But I don't know if they've been talked to, if they've been, or maybe they just see this press thing and just don't even know who I am or what the hell's going on. Whatever the reason, I was able to get some video of the parties leaving, and I haven't had a chance to dump it from my phone. I think it's in process right now. Didn't get there timely enough to shout out anything at Ms. Reed. She and Alan Jackson were heading off together, and then some of the other attorneys trickled behind. So I actually ran into Aiden as well. Aiden Carney was at the foot of the stairs, and so we had an informal chat real quick, like about what was happening today, what the plan is for tomorrow, and I think he was surprised to see I wasn't in cuffs either. And then he said, "Oh, I see you have a press badge." He said, "Yeah, from everywhere but here." So we'll see. I hope that continues to work, because they were ending for the day. And I did have some conversations with some of the troopers, because I wanted to park. You see the nose of that white vehicle right there? That's me. And that has the Starlink. It's over here. Where is it? No, it's over here. That's it. It has the Starlink on the roof. And obviously, the closer it is to our setup, generally the better signal performance we get. So I waited. They usually have cones and or cop cars, trooper cars, all along this street. And when they fled, I asked a trooper, the one that was remaining, I said, "Hey, I just want to pull up here closer to where my Starlink will be for my broadcast." That's how I left it. And he's like, "Yeah, sure, go ahead." Good news. So that's at least for today. We'll see what happens when there's more activity and perhaps more congestion, because it was all breaking up. You'll see when we post this video that I took. Yeah, it was pretty hectic, and it was the usual scrum as people were leaving, and I dove into it, but just a little bit behind to really ask much of those that were leaving the scene. Hey, Scott, happy to see they're letting you down. Yep, so far, I'm such a threat. I mean, it's just, the salaciousness, the activism. I could see how they'd be frightened of me, can't you? So I was also talking with our buddy Tom, my fellow complainant and plaintiff in the case against the in federal court against the state troopers. And so before I get into some of the Q&A, because I'm happy to bring Tom in on that mix as well. If I could see what I was doing here, Missy, could you bring Tom in? Because I'm not sure I can hit his little thing here timely enough. Did I hit it right? There we go. Something's happening. And not.
There he is. How are you today, sir?
There he is. Hey, I'm doing well, sir. Are you wearing a tie?
Yeah. Every time I go to court, I wear a tie.
What's going on?
Oh yeah, man.
When you're outside prowling, has that helped you? I don't think it's helped.
Not once. Not once has it ever helped. Not once. But I look good getting in trouble, right? That's what it matters.
You look good. That is the key.
Yeah.
When you're going into lockup, you want to look your best.
I got a thing for Jerry Garcia. These are Jerry Garcia ties. I got a thing for them.
Nice.
I love them. Oh, I love Jerry Garcia.
You may find this hard to believe. You're not alone.
Hey,
I'm from San Francisco, so you don't have to get me started on Jerry Garcia.
How is
howdy
it
to you?
How is it in the buffer zone? I'm curious. How are you? Are you comfortable there, or are you still got that little edge on waiting? Yeah,
everybody's gone, and it reminds me of some of the days I was here, as you have been, following when there are less sensational things happening, and it's pretty quiet. And once they called it for the day, once court was ended for the day, it was like rats off a sinking ship. Everybody bailed from this area. So, and I was just telling our folks that I did get trooper approval, trooper seal of approval to park a little closer so I could get the Starlink up and do this from here. I'm not sure that's going to happen every time, just because, if they're in session, I think they're going to be a little more hard ass with.
You're on Starlink right now?
I'm on Starlink right now.
The pitch is pretty clear.
Am I breaking up at all?
Nope.
When you do the, I know you're contemplating getting one, and I totally.
I'm looking at them right now.
But you use your cell phone and you scan the sky, and it does a cute little animation. I mean, it doesn't need to be cute, but it is. And it shows like little bits falling into your phone until you get 100%, and that means it scanned the sky where you are. Then it evaluates that and tells you whether you have good signal, some interruptions, poor, and then it'll break it down into for video streaming versus video gaming. It's
and it works when you're driving also, right?
While you're moving, I have not given that a try. Well, let me correct that. I've not given that a try on purpose. I can't say I haven't driven off with it still on the roof of the car.
Right, and then forgotten about it.
And then realized, shit, and I've stopped and pulled it down. But, considering the limitations of, it has to have the right perspective to the sky, because you can then, as it's showing you the signal strength, you can turn it and match it to the strongest signal.
Gotcha.
So as you're driving, unless you're in the Mojave and there's nothing anywhere blocking your line of sight, you're probably going to come and go signal-wise.
I saw one that was motorized. It was automatic.
Yeah. Oh, that tracks the best
The
signal.
new one.
I believe it.
Yeah. It tracks itself as you move. So I'm looking at it.
We're just simple folks here. We just have the Starlink Mini. We don't have the NASA version. But if you can find one and afford one and do that, all the better.
And I see Nan in the chat, so I just want to say hi to her. She's an absolutely wonderful, awesome human being.
Yes, she is. I've met her a couple of times.
She's great.
Known as Laferio.
Laferno.
Oh, Laferno. What? Laferno?
It's a thing. Forget it. We're trying to get the Supreme Court to see how unconstitutional this buffer zone is and how aggressive the police are being in the policing of said buffer zone. Like, they're ready. Do you see how quick he was in the back of that truck? Like, boom, he's in.
Oh, I know. So let's talk about your latest experience, because we know what led to your being a co-plaintiff in our case against the troopers. What has happened since then with you?
Oh, this morning I went up to ask Trooper Hardman about the lawsuit, the stay that we have.
Oh, okay.
Right? I went to ask him a question about that. And he specifically jumped out of his truck and said to me, "You are out of questions."
I've exceeded 20 questions.
I was allowed one, and that was way back at the very beginning. And he was ready. He was ready to lock me up right then and there. All right, I'm going back. He was mad. I was right where you are on that side of the step.
This is the deed of registry right across the street. You were here or on the other side?
I was on this side at 7:50 in the morning.
Okay.
And I tried to talk to him, and he was ready to go. He was ready to jump out and lock me up. So I just wanted to ask him a simple question.
Well, I don't think those are their favorite kind of questions, actually.
No, so. I'm out of questions. I'm not allowed to. My allocation for questions has expired. I've used them all up.
It's ridiculous. And I was surprised. And again, it'll be different tomorrow, I think, when when they come back from the view and it's more traditional in session. But nobody seemed to care, because I could have made these at home, on my computer.
That tells you all you need to know, right? It's only in regards to this case and only in regards to this. The police want to keep us out. They are absolutely terrified of what we're exposing right now in that court behind you. They're terrified because somebody did something wrong. Their friend, they're all friends with Proctor, who got terminated. So they're taking it out on us because their friend got fired. And they're really, I'm telling you, they're really, really aggressive. And poor Jess, if they locked up poor Jess, oh man, that'd be wrong thing to do, because she's out there holding the American flag every single time. She does a standout down in Cape Cod, 70-something weeks consecutive. She hasn't missed a single weekend holding that flag for Karen Reed down the Cape. Now, that's the human that she is. She's that awesome. And if they were going to lock her up next, No. Just for being there.
And you know that, and you know maybe his more proper name, but I know him as Boa, the guy that was arrested.
Bow.
Bow?
Bow.
Oh, it's Bow, as in
Bow.
some Asian or Pacific Rim name. Okay.
I think he took it from a video game, to be honest with you.
Okay.
Like, that's not,
So-
I don't think that's his real name.
I saw the video. Looked pretty aggressive. You think he toys with the troopers a little bit?
Absolutely.
And so he got maybe what he wanted.
See-
What's the latest with him? What's the deal?
He was here last year, and the buffer zone was in place last year. So he kind of knew about the buffer zone. And when he first had the interaction with that Trooper Hardman, he should have asked him what's the deal with the buffer zone, but he just shushed him, get away, go. And then when Bao was asking legitimate questions, like, what's going on? Like, what do you mean? I missed that sign down the street.
Right.
Hartman took it the wrong way, because all Hartman saw was the trooper pointing, the sign's over there, and Bao's going. So from across the street, it may have looked interactive like that when they were both discussing the buffer zone sign.
Okay, so for those who have seen this, there's a sort of a conversation going on with 2 or 3 troopers, and then from across the street, you see a trooper charge in. That's hard. Is that right?
Yeah, I think I can pull it up.
Oh yeah, why not? Yeah. So where is he now? Where is Bao now?
Last I heard, and I don't know, but I think he's out. I think he's been released.
I mean, what would did you ever hear what the charge would be? That's what I want to investigate.
I don't.
Charge is
I don't.
Violation of the buffer zone in the first degree. I mean, that's ridiculous. Here's 2 problems that the troopers have. First of all, they're not bright. That's the first problem, and nobody's giving them direction. It's kind of a combined effort. The other thing is, do they really think that by silencing or attempting to silence people like you and me, that it's going to have any impact on the world learning about this case and what's going on? Of course not. But that's how dumb they really are.
So I have it. I did, but I don't want to play this one.
Oh.
Trying to find a good one here.
What do I mean, I've only seen one that was on his site.
Yeah.
You have a different one?
Yeah, there's a couple different ones. Mazza Media.
Yeah, that's his, right?
Yeah, he got a good angle at the whole.
Did he have
thing.
somebody else there recording? Because obviously his recording device was slapped from his hands. So
took it
was
right
there somebody
away.
else recording that shot?
Um,
I'd like to see that one. I've not seen that one.
Yeah, there's an outside one.
Okay,
Not
a wide shot, not a point of view shot. In the business, Tom, we would be calling that the point of view shot. But
What do they call it? A wide shot?
A wide shot, yes. Establishing shot, wide shot.
I'm looking for it. Maz is great. I'm looking for his video here.
Okay, while you're looking, I'm going to take a look at a couple of questions, if I can see them in the blind.
Mazza, what'd you do with it?
Well, this is from Diz. Diz always has very good questions because she's here all the time. Why is he, meaning Brendan, I believe, allowed to enter clips and evidence without foundation? Well, the clips that we're talking about here, of course, are the apparently random seeming clips of Karen Reed in interviews on various shows, Dateline, the ID show, which was called Body in the Snow, now available on HBO Max. So we know that they're dropped in like little pacers. To be honest with you, I like that style. I like that presentation. It's a little sorbet, a little palate cleanser as you're moving between one witness and the next. I have no problem with that. The reason they're coming in is this has been fought about way back. As soon as the documentary aired, and I have a feeling before that, the prosecution had their hands on the other stuff too, Dateline interviews, etc. They planned on using it. So these things were brought up very early in the process through not just motions in limine, but even before that. And so it's been fought over for weeks, maybe even months prior to trial, and the court ultimately ruled that those could come in. So that's all they needed. So now they're putting them in. You're not going to have to hear from the, for example, the director of the Body in the Snow documentary. You don't need that now. You might have. And you have to be, you have to think about these things as preparing a case, fighting. What are you going to fight about? Is this a battle you want to pick? Because you will lose ultimately. So do you want to force them to bring in some foundational, here, this is the director. put her on the stand, have her say, yes, we did that in the course, normal course and scope of the production. Here's how it happened. Here's how the video was maintained. You know, why don't you just shoot the jury? I mean, it's just brutal, and you're not going to win that case. So just pick your battles. And the defense knew that this was going to come in. Let it come in, and let's not, piss off the jury any more than we might have to.
And again, right? Imagine if Karen's fighting this whole system that is set up the way it's set up now, and she's trying to fight it, and she's gonna win, obviously, by being found innocent. But this is the system that she's got to fight every single day. And again, Aiden said it. They have the guns and they have the badges. They have the power. Like, what are we gonna do?
I mean, it just sounds so third world, you know.
It does.
It's really it's horrible. And speaking of Aiden, as I wandered up this morning, I bumped into him, and so I have some wild sound and wild video as the parties were leaving today. But it's trapped on my phone, and I had to sit down and do this. But I will upload that so folks can get a flavor for what it was like as the day ended today. It was pretty civil, I have to say. There wasn't craziness. There were a ton of troopers around, though. No
Doesn't it seem like there's more troopers than supporters? I mean, they're everywhere. They really are.
It could be maybe two supporters for every trooper. Maybe. It didn't look like a lot. I mean, I got here a little later, so you guys would probably hear more in mass and in force earlier in the day, right?
Yeah. So you've been here in the past, and you've been here currently. Have you ever got a vibe that we or any supporter has been like unhinged, like in need of state police assistance?
No. I've never seen people more passionate. I'll tell you that. And I've been, covering stories around the world, and so I know it was funny. And I'll share this. I don't think you'll mind. You said something earlier about apologizing for my experience here, because it shouldn't be, what people take away from Massachusetts in general, or this area in specific circumstances. This ain't nothing, man, compared to other stuff I've seen here, there, and everywhere, foreign countries, even in our own. Even stuff like the Ahmaud Arbery case is a recent example. I mean, that got intense and that got scary. This is the people, to get back to your point, passionate. They care. They know that this case is a symptom of a big disease here, and they want to be heard on that. The other thing I take away is I've not once seen anybody supporting the prosecution, although somebody did just drive by. And this is probably your experience too. They just drive by and yell, "Garrett Reed's guilty."
Yeah.
And then they just keep moving. So I'm still waiting for somebody to come to me with some substance and say, "Here's why we think she's guilty of whichever of the charge. He did this, and this. How do you explain this, and this?" I want that conversation, but nobody seems to have the stones to do it.
It does, because it can't. That is a fairy tale. What the conversation that they would have with you is nothing but a fairy tale, because it can't be true. Nothing
So what do you think? Well, I mean, what do you think? Sorry to interrupt, Tom. What do you think I do that a lot. What do you think is the motive for those who are so angry about that? Are they all connected to the cops in some way, or what?
Everybody's connected to the cops. I don't want to say it's inbred, but it's so generational.
Perhaps?
It's generational. Like, it's really that deep, where it's grandfathers, new grandfathers, and this grandmother worked with that grandmother, and the history over generations. That's where we're at today. This is what we got.
So to get to that position, the Karen Reed is guilty position, with all of these, connections and bloodlines, I still have to think that somewhere the foundation is supporting the cops.
Well, I would say the people that think Karen's guilty, right off the bat, at least 80% of them specifically don't like Aiden. So if Aiden said the sky was white, they would say, no, it's black, and they would hate him and argue with him for the day till forever, just to argue with him because they don't like him. So it's not fair to put them as, anti-Karen Reed people. They're not. They're just people that hate Aiden, and they're using Karen Reed as a way to say, we don't like you. And
So
he's broken. This is a huge story. This guy's broken. I mean, huge.
And fleshed out. I mean, the story was a little kernel, and he popped it. But that begs the question: why do they dislike him? Because he exposed the story? If so, that still doesn't answer the question.
Well, it does,
what would make them mad about exposing the story?
because he's exposing the truth, which is all this corruption, all this friend of a friend of a friend. I mean, the guy across the street, who's the deputy chief of police, deleted his own ring camera footage from that morning because he determined there was nothing on it.
Yeah.
And
I know. I mean, there are lists and lists of those kind of questionable actions, and they all seem to be linked to law enforcement. And it seems like that's where the bright line is. You're either for them and their investigation and their conclusions, or you're against them, meaning you're promoting Karen Reed.
So that there are people that really think that she did back up and hit John, and I'll give them that. There are some people that think that happened, and they're allowed that too. The physics and the evidence don't support that in any way. You can't make it fit. It doesn't fit in the hole. It doesn't go. It can't. He doesn't have a broken collarbone. How can he get a pirouette up and down, sideways, texting, upside down, land on his head, and then finish the text? It doesn't happen.
And have time to turn off his phone.
That too. He forgot to lock it.
Yeah. So, all of those things make you wonder what the hell is going on. And I will say what I said at the end of trial number 1, and it's only first week. I've seen nothing yet to change this opinion. I don't know what the hell happened that night.
Nobody does.
No idea. So does that mean she's innocent? Well, we don't have a system that determines innocence. We have a system that determines guilty or not guilty. And if you don't meet the burden of proof, you don't get guilty, you get not guilty. So I don't know. You get to the end and say, what the hell happened? That's not guilty.
So it's kind of weird. Last trial, we were all really almost convinced that there's no way they can convict her. There's no way, because they didn't prove it.
The problem, and I appreciate that passion, I do, and I see it with all of the hardcore Karen Reed supporters. And I think it's great. But what you're forgetting is the wild card that is a jury.
Yes.
I mean, all I have to say is OJ.
Listen, all I gotta say is Ronnie. That they dismissed ACA. They thought that's a distraction. These are PhD guys. These are like brilliant. These are like the people. They work on NASA. NASA calls them for help. They're pretty smart people, but they dismissed it. That scares me as somebody potentially that would be like on a jury. Like that scares me that they would just think that doesn't. I don't understand the jury. We shouldn't even be here.
I know that's definitely an overwhelming comment by folks who are so frustrated with this process. Paula B says, wasn't in her statement to the grand jury, and I'm assuming we're talking now about Kerry Roberts, claiming Karen Reed's Google search request that brought the indictment. Certainly it was a factor, but I think even if you take that out of the mix,
she was still getting indicted. Yeah.
Yeah. And, there's the old saying that you can indict a ham sandwich, and it just simply means you don't need a hell of a lot. The standard, the burden of proof is just somewhere down here. Probable cause. It's nothing. If that were the only piece of evidence, maybe that'd be an issue, but not when there was so much other stuff presented, which may be refuted and a jury may be convinced did not happen as proposed. But remember, grand jury, it's just the prosecution putting on a story.
Right.
There's no defense at the time of a grand jury. Nobody to stand up for anybody that's been accused. You just go, you sit in there, you get the indictment, you move on.
They sent twice to get an indictment on Aiden with the grand jury. Twice they failed both times.
They didn't get one.
Twice they failed. That's how much of a struggle that was. And you know what? I wouldn't be surprised if some of these people that are coming up on the witness list here demanded that, because they demanded Morrissey with that hostage video, right? Did you see that?
August 2023, is that the video?
That's that video that he made. What the DA did? He never comes out and says stuff like that. That's what?
Yeah, and then he's disappeared into the woodwork. which is probably what he should have done before he made that statement. And I was surprised when we heard from Kerry Roberts yesterday. She talked about how many times she met with law enforcement or the prosecution, that, Morrissey is reaching out to her personally, having meetings with her personally. And I know Aiden believes it's all revolving around their attempts, meaning the McCabe's, their attempts to shut him down, to silence him. That did not come out in court, and it would not, because it would be inappropriate. But just the sheer fact, and that's all the jury's going to hear, why would they be meeting with her 40 to 50 times? Why? That just sounds like a hell of a lot for a percipient witness. Important percipient witness.
Because Aiden would write a story, and they would say, look right here. See this? He said the truth right here. You got to get him to stop telling the truth. That's the problem. He's so effective that they got to shut him up. They threw him in jail already. Took his civil rights away for friggin' 60 days.
And the jury doesn't get to know that. They don't get to know the whys. So I try and look at the evidence as it comes in, as they would hear it, not with all the clutter that we know.
And that's kind of the problem, right? We get almost information overload. We know so much about it that
you're right. You're right.
Yeah. And
so
the jury is what
try as best you can to just say they don't know that. That's not going into their decision. And after the fact, if you don't like the decision, you can't say, well, what about this, and this? Doesn't matter. If it's not in this trial, it ain't relevant. Just maddening.
Did you see how they're going they're going for a field trip tomorrow?
Yep. I didn't. What details do you know about that? I just heard there was.
They're probably going to go to the waterfall. Probably going to go to C.F. McCarthy's, and they're probably going to go to 34 Fairview, right?
Yep.
And I wonder if the car will be there, because last time they put the car in the out front, not in the driveway.
Well, I think, and the car is going to be there according to the latest. That all of a sudden Hank Brennan acquiesced to that. He was against it.
It's like they're staging it. They're like putting it up. Like, this is how it happened. Like here.
The first time it was parked right out front for the jury in the area that I don't know that it's disputed that it was in that general area. How many times it moved? Did it move backwards into Officer John O'Keefe or not? Those are disputed issues. But the fact that it was in that position at some point in the evening, I don't think is disputed. So they're going to see it in that setting for what it's worth. I think if nothing else, it's convenient. It's all there. It's one view. We're not going to recreate.
Get done over with.
Yeah, you're not going to recreate. We're not bringing in movie directors to recreate a snowy scene and try and give them a sense of what it was like that night. That ain't going to happen. You can only do so much.
Matter of fact, when the wind blows, it looks like it's snowing behind you, but it's the little petals from the trees, the little white petals. Yeah.
Well, it is. It's beautiful here. It's kind of like it's like Washington, with
the cherry blossoms.
The cherry blossom festival.
Yeah.
And for some reason, as allergic as I am to many things, it ain't those things. Luckily. It's beautiful. Lovely. Yeah. All
right. Scott says, no Lexus this time was the word. No hanky panky is bringing it. Other shell game by Hank. Yeah, I mean,
so he's saying now it's out. It was in and now it's out.
Maybe. I mean, I think he's referring like Hank is playing that shell game, right? Is he going to bring it in? Is he going to come it out? Is it going to be there? Is it going to be on a flatbed? Is it going to like? I don't trust Hank.
Yeah. Well, I mean, I heard the court say that's what's happening. So until I see otherwise, I'm going to assume that's what's happening. I don't know that he would have, I don't know, in this circumstance, the authority to say, change my mind, forget the car. I mean, that can't be a unilateral decision.
Right.
So we'll see. We'll see what happens. I wouldn't mind seeing it on a flatbed because it was on a flatbed a few times. In fact, when it was hoisted onto the flatbed from Deitman. Is that right? Deitman? Dighton, sorry.
Dighton.
Dighton. We were talking about last night, those dogs from Game of Thrones. And I said, well, maybe a dog came along, a Deitman dog. Anyway, we know there was a flatbed involved a couple of times in the moving of this car. So I wouldn't have a problem with it on a flatbed.
Yeah. So, I mean, they have the car, they have Karen's vehicle in the snow with the tires spinning in reverse. You think that maybe could go to 24 miles an hour in the snow if you're like stuck in the snow? I've done it. I've had my car like at the 60 when I've been like third gear driving in the snow with my car, spinning the tires the whole way long,
Did you have positive traction?
Yes. Always have posi. I had a 69 Roadrunner. I got drag racing. Like a cut drag race, that kid with a 427 Chevelle.
As we know from Marissa Tomei, that positive traction not available until after 66 or 67. So you had some of the early gear.
69,
So,
baby.
Proctor's missing pension. Hank said the Lexus being there would be misleading. That was his early argument.
Right.
He turned around and
Right.
said, if the defense wants it, they're okay.
So that's
full of
that
shit.
shell
We
game
know
that Scott's talking about, right? Is it? Is it not? Is it? Could be. It can benefit them. It'll benefit us. It's just. It's not a definitive.
It's just tell the whole story. That should not be a persuasive piece of evidence at this point. It is what it is. There's plenty to talk about. There's plenty to see. Plenty of video. Plenty of mystery around the rapidly increasing number of lens pieces found at the scene of the crime. Those are all different issues.
Have you seen how Hank's using clips of Aaron's interviews to
Yeah,
almost put her on the stand by herself? That is that dude. Come on.
I mean, I know that people have asked, how does that come in without foundation? We just talked about how that was handled pre-trial, and I admit I like that presentation style. I do think it's effective because it keeps the jury
it's effective.
nodding off.
Yep.
And speaking of Brennan, my buddy, when I met him across the street here, a few weeks ago, and he didn't want to engage. I'm not sure why. He was maybe I had some bad breath that morning. I'm not sure. I asked him how the adventure was going, and he just said, nice to meet you. So this morning, or as they broke for the day, I was kind of just hanging out, and he was having a long conversation with a trooper over here where he's parked. He's parked on this side, where just a few cars get to park. There's a little sign, District Attorney, you're special. And so he was at his car. It was a long conversation with the trooper. Who knows what he was crying about or wondering about, but I can't imagine what he, in this case, would have to have a long conversation. I mean, you talk about the weather.
Buffer zone. 100% buffer zone.
Yeah, and what? Making sure they're enforcing it. I don't know.
Well, look at what he's doing in the courtroom. He did the buffer zone. That's got his fingerprints all over it. That's his MO. Like push him far away. Get him. And now, you ready? They're telling people to not hang around the buffer zone after 9 o'clock.
There was I just had something opened up here. Let me see if I can find it again.
That's just so not fair.
You see this, Nosy Rosie, Justice TV? Did you hear about boots on the ground getting pushed out from the buffer zone because of a business owner? And just so folks get a clue of what's going on, there's two boundaries to the buffer zone. I guess technically there's four, but two that really matter, right? They're both on High Street here. One of them is down to my left, and that's the one that is furthest away. It's past the church. You're pushed into a little splinter of ground on either side.
It's dangerous there.
Of the
It's
road.
dangerous.
It really is. They have put cones up all down that street so nobody can park there. But I think that's probably more to be a pain in the ass than to be helpful. So they're down. So that's one location. The nearer location, and the location I'm assuming this complaint, if it happened, came from, down this way, it's only 200 feet. It's in fact where the original buffer zone was, right?
Correct.
And there are businesses down there. There's the Bagel Cafe. There's a couple of other businesses. And I could see how that area could become clogged if it's a big turnout day for the support.
We packed those businesses downtown.
Yeah,
like
you're making
the
money
bagel
for 'em,
place,
that's
the diner.
You have the ice cream place you love to go, isn't it? Is that an
yeah.
ice cream place you go into?
I mean the dessert place. Yeah, like we spend money in the economy there. Like, so we're making a positive impact on the economy that they wouldn't have. Hence, Karen Reed, right?
Yeah, I mean, and if you look at this area, aside from whatever the court traffic may be, and on most days it's crickets like this, a few people coming and going. It's not like their normal business is thriving.
Correct.
During the day. In fact, I'm not even sure when their hot time would be. There's a drugstore.
CVS is down there.
CVS.
Yep.
But really, it's not like a tourist destination.
No. And I don't know. Have you been behind the courthouse at all?
Yeah. Where
you see the houses, all the old houses. No, look at the houses. They're beautiful. Yeah. So it was a small community back then. Like your neighbor, you could reach out and touch his house.
Right. And of course, like most new communities, when this was first started, they begin in the town center, and then the houses start to grow from there. So these are the original residents of Dedham, or at least the houses are.
So, and one thing that I will say that I have noticed is all of the Karen Reed supporters that are out there, they're being very respectful of people's property. Like there's a fence that people were not doing anything, they weren't writing on it, they weren't, leaning on it. This guy, he was growing flowers along the edge of his fence. Nobody stepped on him, people picking up trash. So we're leaving the place cleaner than it was when we got there. And so it's not the residents, because like the guy came out and I was talking to him and he's okay with it. He's all, do what you want. He was
Let me
just curious
contrast
what was
that
going on.
Let me contrast that with like some of the universities that are having protests about various things. Violence, damage. Why? Because they don't give a shit. They don't live there. A lot of them are just paid to be there.
And Black Lives Matter running rampant across the country. Remember that?
Guys,
Just stuff was getting
course.
destroyed, burned, tipped over.
And you guys, this is your community.
Right.
So why would you trash it? So
We didn't even have a skin knee last year. Like we took care of our own. And you should, I wish you were there. God love the girls. The girls down there, they fed everybody. And we're talking 100 people every single day showed up. They all got fed. They all had water. There were many days when it was at least 100 degrees and we're melting. I mean, they took care of us. So yeah, it is our community and it is the people there. And this is what we got. And unfortunately, you're welcome to Massachusetts and seeing Bao get arrested, thrown right in the great boom. Next, who's going next? Like it's
more,
just,
I'm sure of it.
it's sad that you have to even be part of this and talk about it.
Thanks
We're better. Massachusetts is usually better than this. This is just a hiccup, I think. I hope.
Yeah, believe me, I'm not burning down the whole state from what I've seen in this community. Believe me. Thanks to that girl, $10. Appreciate that. This relates to the clips that you were talking about and I was talking about earlier, Tom. Jacob, do you think she should testify to explain the clips? What's your take?
No. Hard no. You never testify. That's why
totally
you have
agree,
the attorneys. And no matter how much you want to say, you can't. But the lawyers will speak for you.
This
And
is one of the rare
unfortunately,
cases
where we're at.
We've seen in a form a lot of Karen Reed testimony, right? We've seen it
Mhm.
through all of these different interviews, which most attorneys cringe at the thought of their client being that out there. I know I do. It is frightening. But having said that, she's a pretty good spokesperson for herself, and she kind of hangs it out there. Like some of these clips that, of course, the prosecution likes, she comes off maybe as a little aggressive, maybe saying some things that weren't the smartest to say at the time, but she owns it, right? And the jury can look at it and decide whether they think it's because she's an evil murderer or because she was concerned at the time about her boyfriend. I mean, they're going to have to figure out the motivation for some of those things being said, but she should definitely not take the stand. The other reason, you take the stand generally if you got no other hope. It's a Hail Mary, or it's a case of he said, she said. The Harvey Weinstein case is underway in Manhattan. I've been down there for that during their jury selection. That's a classic. He said, she said. In this case, 3 she says. So there's a very good chance, and I've been told that he's preparing to testify. That's the kind of case where you might. Oh, also, by the way, that he will never see the light of day, either because he's going to die of cancer and other illnesses before any sentence ends. And his sentence probably won't end because in California, he's already looking at life. So he got that's the classic example of nothing to lose.
And, it's a shame too, right? Because I can show you 5 or 6 clips where Karen Reed is unencumbered and she's real and she thanks every single supporter that's out there genuinely from her heart. I have tons of video of that, right?
Sure,
so
sure.
She's not a dumb lady in any form, right? So her doing that is pretty good. They won't play anything though. Anything that she said to me, thanking the supporters, they won't. They won't play that. Come on, Hank won't touch that. No way, because that shows you who Karen Reed is.
Well, and again, and somebody had asked about, and we'll get to this question about how Brennan is doing. That's not his job. You know, I look at it from his perspective. His job is not to make her look better. That's not his job. So you're not going to see that. Micah says, "Hey Tom CPU, I love the meme behind you. As we wrap up, care to share some pictures of you?" What I can't see as well. I'm in the middle of a blinding light.
I have it's an 86 300ZX.
Oh, nice.
It's just a toy.
Nice.
Yeah.
So is that you have that car? That's yours?
Yeah.
Okay.
Yes. I've had a bunch of cars my whole life. But
Me too.
that saying is from Alan Jackson said it in court, and it stuck because he was repeating what Colin said to the Advantage Boys. So Alan Jackson said it in court, and it kind of stuck because when you see a lawyer say, you know, pull up, bitch, it's kind of, especially high-end lawyers saying stuff like that, it kind of gets you a little like notices, you know. But I mean, and again, I'm sure when this is all said and done, it's gonna be the God correct answer this time. But enough can't be said for Alan and David and Liza and Mrs. George, and I mean all the attorneys there, you know.
Yeah, well, there's no doubt.
You can't say enough about them.
Yeah, and with the schedule that Judge C has put on them.
How about like get here right now?
Tail on stuff, right?
Did you see that yesterday? Get him here tomorrow. I'll bring him in tomorrow. I'll be here.
Deal?
She cuts a half a day. But
yeah, and no Zoom. No Zoom.
She told Aiden, be here in an hour. Or they scheduled him and never told him. Oh, by the way, you have a 9:30 appointment. He lives an hour away.
Yeah, yeah.
And his attorney. Both.
Yeah, it's crazy. I mean, that kind of sandbagging is just wrong. I mean, you know, be adversarial, represent zealously, but don't be screwing people. Don't be trying to.
And if they just did that, if they just tried to prosecute with the evidence, they can't. Because there's nothing there.
On that topic, Kathy says, what do you think of how Brennan is doing? Now, I know you're going to be kind of biased. I try to back off a little bit, look at him as an attorney doing his job. How do you compare what you're seeing from Brennan with what you saw from Lally?
Oh, way. Totally. I think Brennan is doing a good job considering the cards that he has in his hand. He got dealt a bad hand. Sorry. And Lally didn't know how to play this hand out. I think Brennan does. And I think he's not only that, I think he's trying to bluff a little bit. Right? And I think he's also possibly have something that we don't know. He may have an ace that we don't know in his hand. Right?
Some sort of literal smoking gun, like some admission that we don't know about, or
how about like an inverted video that the judge just allows in? Yeah, bring it in. Yeah, don't worry, just bring it. No chain of custody. Nobody knows where it came from. That's the ace in the hole that he I think can play.
Manufacture something that the judge allows in because she's a little loosey-goosey with some of that stuff.
I don't trust him in that way because he's a good attorney, and if he can play that card and win, he's playing it.
So
That's my thought.
Yeah, I don't disagree that he's a good attorney. We know that. His manner with the jury is slightly better than I expected. But he's still kind of annoying, and that comes through. And I think the problem with that is when you seem to do something a little shifty, it's exaggerated by his mannerisms and his sound.
Right.
But I think he's doing a decent job representing his client, the Commonwealth. And I do, again, say that the way he's presented these little nuggets to break up testimony is just a great presentation technique. I don't care whether I think he's full of shit or not. The technique itself is good. You want
effective.
To keep the jury engaged.
I totally agree with that. And again, right? He's doing good, but you can't discount what Karen's attorneys are doing either. I mean, they're just as good coming back at him, right?
I'm waiting for that question.
So, I mean, I'm happy to see this play out. Unfortunately, I'm still not that like you said, that wild card, the jury. We don't know about that jury. We have that Ronnie factor. Like, you gotta throw this out, not look at that, not look at this, but that's all right. The Ronnie factor, I don't get it.
I do agree with you that it will be tough to find 12 people that would convict. That because remember, to hung jury, one person, you're
Right.
done.
Exactly.
Getting 12 is so difficult. So what concerns me in terms of the evidence I've seen the first time, maybe I'll change my mind this time, is jurors, if they get in a battle with one another, and then one's putting another in a headlock, and you got some alphas going against some less strength-filled or convicted people, and I don't mean convicted as in judicially, and they roll over. They just melt to the stronger personalities. Sometimes that happens as a compromise verdict. So in this case, you got an opportunity to do that. If you throw the top charge out, second-degree murder, which is insane, I don't know anybody that would go for that.
Right.
I'm setting that aside.
That's a stretch.
We've seen already Hank Brennan getting into the alcohol use, right?
Mm-hmm. Yep.
And we know that's going to be a theme. And we know it's going to make it look like, she wouldn't take a urine test. And I think Yannetti did a good job of saying, well, isn't it true she was never alone? That because of this psych evaluation that she had been taken.
That's right.
She was never totally alone. Who wants to take a pee, in front of somebody?
Nobody. Right.
So I think he did a good job of at least minimizing what looked like her saying, I'm guilty, so I don't want to pee in a cup. I mean, that's the prosecution's argument. She's guilty. She didn't want to take a pee. And so they've done a great job of watering that down. I just don't know, as we move through this trial, that some jurors may not latch on to the alcohol thing.
Right.
And just go with that charge. And there is the alcohol-related driving charge.
I mean, they said last trial that she had 9 drinks. I mean, she paid for 9 drinks because they all did shots.
Yeah.
And she said she took her shot and put it in her drink because the drinks were watered. They were light. So, I mean, that makes sense to me now, right? So one drink is now 2, right?
And they did
double.
When they did the blood test, and we're going to hear about all of this, how they do basically an extrapolation, and they say, well, if we took the blood at 6 in the morning, give or take, 7 o'clock in the morning, and you're at X, then we back that up retrograde to at about the time of the incident, you were Y. And that's a science argument. That's what's going to happen. But most people will just hear 8 drinks, 9 drinks over the course of a relatively short time. And they may not hear any more than that. They may just find that is enough in their minds to say, what the hell are you doing driving? And who knows what happened?
Well, the beauty of that is all the testimony that they have from everybody, they all say she was normal. She didn't seem drunk. She didn't slur her words. She could walk fine. Like, she was not drunk, according to every single person. I'm sorry, every single trained first responder, trained alcohol sobriety individual. They were all trained, and they knew she wasn't drunk.
Well, here's something that hasn't been talked about a lot, and I think it can be dangerous for a defendant to put this in the mix. Alcohol use, as with any CNS depressant, central nervous system depressant, Xanax, Versed, Halcyon, there's a tolerance that's built up. So 8 drinks to me or you, I might be on the floor. I mean, my tolerance isn't up there. But it's very dangerous to paint the picture of your client having built up a tolerance to alcohol to the degree that what she drank that night did not impact her. It's almost an unspoken understanding that, well, if she wasn't affected after 8, 9 drinks, she must be pounding them regularly. It's an unspoken danger.
Right. No, see, and people will go there. I absolutely agree with that. And you can get from here to there. But Karen just wasn't that type. I mean, the text messages, John was the one always wanting to go out drinking. She was just whatever, like,
One of the earlier texts when they were having their, that horrible knockdown drag out text battle. Oh my God, the blood,
the horror.
Oh my God, I had to look away. She brought up that she was going to go out for a drink. It was earlier in the afternoon, and there was some back and forth about that. Hey, if you need to go out and drink, you need to go out and drink. Go ahead. So there's a little of that. Not crazy. Let me give you an example of this CNS issue and what happens, Tom. It's a danger when you try a case in which you have to become sort of an expert on that. You become annoying about it. That's where I am with CNS depressants. I represented a pharmacist in a case. He screwed up. You ever see It's a Wonderful Life?
Yeah.
Yeah. Remember Mr. Gower? He put the wrong meds. He was distraught over the death of his son in war.
Right.
They put the wrong meds in, and he has little Jimmy Stewart go to deliver them, and he realizes that they're poison. He goes back and gets smacked in the ear, but basically saves this person's life. Our pharmacist put Halcyon, the strongest CNS
Sleeping
depressant,
pill, right?
in a Xanax bottle. Okay, and the multiplier is something like tenfold. So if you or I take a Halcyon, we're out. We're done.
Done. Yeah.
This particular plaintiff, and we admitted liability. We screwed up. My guy put the wrong pills in the bottle. So we're here in front of the jury to argue about money because she wants a ton of money. We don't think that's legit. So I get her on the stand and we go through her use over time, all of this medication and alcohol. And at one point, I was asking her to describe how she felt after taking some of these high-dose meds, and she was still conscious. She said, "My hair hurt." And I said, "I'm sorry, what?" I knew that question and answer was coming, but to reinforce that with the jury, that's how deep into CNS depressants this woman was. She's not only out, but she's feeling kind of phantom pain in her hair. Anyway, so the result was fine. We had to pay some money. We had to because he was wrong.
Yeah, it was an accident. Yeah, that's why you have insurance.
That's the way it goes.
Right.
Dump truck. You guys have a lot of traffic on this street. I do know that. So my point being, can't really bring that up with Karen Reed. It just makes it, you don't want to paint her as a lush, and that's why she was less affected that night.
Right. And Scott said, and he's right, she was the most sober one of all of them. Like, she was the one. She was the most sober. Everyone else was just done because it was the storm was coming. No sports tomorrow for the kids. Everybody's snowed in. It's one of those, weekend benders you do, right? Because it's what you do in New England. You stay in and drink. So it's not. It's like a hobby. It's just what people do, right?
Cops too.
Yes, exactly.
Remember in that audit, we played some of the, I called it the clown hall meeting.
Yep.
Talking about the audit. And these are the guys who did the audit, and they're laughing off an officer who had drinks either at lunch or right after work in the cop car on the way home. Oh, come on. What's the big deal? It happens all the time. That's the attitude.
Yes.
That's the attitude. So that night, we're all drinking. We're off-duty cops. We're not. Who cares? Okay, Joanne M. Jedi Platypus, says, so Mr. Limpy, non-photo data expert, is he going to give testimony sprinkled throughout the trial? I believe that's Guarino that she might be referring to.
Yeah, Mr. Limpy, because he got hurt. He was in his cruiser and got hit. He looks good for the camera. Him and Kyle both injured on duty, so they can come to the trial, but they can't go to work.
Well, it's interesting. I think that I don't know if the court realizes what she is saying and how it's affecting the jury, but she says to him, he's been on twice now, feel free to stand or sit, whatever is most comfortable. Mm-hmm. Now, they see him come in, and he has a visible limp, right? Okay. So maybe they're just putting that together. Oh, the guy has some issue, and standing is maybe better for him. But it just, in and of itself, sounds like a weird comment for her to make. And he has been sitting down, right?
Yeah, he's been sitting.
So he's going to come back, and Joanne's question really is, why is he popping in, popping out, popping in, popping out? It generally has to do with what they're about to use, and do they need a foundation for that? So again, you could put this guy on the stand and have him there for 3 hours, laying the foundation for every single piece that's going to be introduced in this case, and you will want to shoot yourself in the head if you're in the jury. So by breaking it up, using him to lay the foundation for the stuff as it comes in, or more contemporaneous with the stuff coming in, he's really doing the jury a favor.
I don't think Guarino reading text messages is worth. Why are we doing this? Like,
remember, they wanted readers.
Yeah, but Guarino's doing it, and this guy who limps in court. Aiden's got a picture of him walking perfectly fine after court.
Interesting.
So
you think that
don't believe everything you see, especially in this case, and especially
I'm going to keep an eye out now.
I'm almost convinced, I'll go this far, that a majority of the video that we're going to see has been edited and altered to a point that does not benefit Karen Reed when it should. They have changed that around. They've taken their cards, and I don't like this card, and they went in and took the card they want and put it in their hand. That's dirty games. And I believe the Commonwealth is doing that. Because Garino, I'm sorry, Fanning and Crawford own a video data company that specializes in altering and in producing and clipping and making video.
Well, all I need to know is in the first trial, it was only on cross-examination that there was an admission that the video was inverted. That's all I need to know. Everything that happened after that reinforces that trickery. You know, hey, how come new pieces of video keep popping up out of the middle of nowhere? Didn't we ask for this, 6 months ago?
And these are the best we got in Massachusetts. Like, you can't even get great. That's the best we got. That's what we got. Inverted video, guys. Trooper Paul. Have you seen Trooper Paul? Can you believe they put that guy on the stand?
Oh my God, I felt so bad for him, and I'm not very sensitive. I just felt bad for the dude. Angie, can you read that? I can't read it.
Yeah, all right. The text seems J.O. was a bit controlling / jealous, even towards the plumber. Maybe J.O. walked in pissy / hostile at Higgins, and bam, big fight. And that's extremely possible. Take his anger out on Higgins when he was mad about the plumber guy.
Yeah, it sounds extreme, but sometimes, you throw alcohol on a fire and, things blow up. And we're going to see that, waterfall bar video that Microdots did a tight shot.
Oh, great job. I love Mike. I want to marry Microdots.
Well, that's a whole different issue, Tom.
Yeah, I know. That is an issue. Microdots is absolutely like the best creator I've ever seen anywhere. Like, he puts it all together. Like,
and
puts it
that
on
was
with a bow.
I compare him to the Zapruder film, the way that this stuff's going to be played forward and back, forward and back.
And you ready?
Comment about the car. Oh yeah,
The car.
The car will be there. But why would they need to visit the boss? Well, Gwen Garnett, here's my take on that. You're right, though. First of all, just go to Justice Serve TV and play the video of me driving and walking between all of these locations. You'll get all you need to know. That's
not far.
That's
right.
Oh my God. Well, it's only 2 minutes, give or take, depending on how inebriated you are. It's about 2 minutes walk from CF McCarthy's down to Waterfall Bar. It's across the street, but it's on the same block.
Yep.
That's nothing. And then the drive from the Waterfall Bar to 34 Fairview, 5 minutes, something like that.
What did you think of 34 Fairview? First impression.
First impression, yeah, it's the same with most who have seen the video I did, was the front yard is small. The front yard is what I would, I got a little real estate background, Tom, because I never know what I'm going to be when I grow up. So I'm a broker, and I deal with houses a lot. And to mention,
the Raised Ranch, New England Raised Ranch, right?
It is like a rubber stamp tract home, okay? TRACT. And, typical lot size, typical neighborhood, does not have these roller coaster hills that were suggested that might have had some impact on the GPS information.
Or speed bumps that they claim.
No speed bumps. There are some rises, but it generally not extreme. And the biggest thing is the front yard. And you see the flagpole, and you see the fire hydrant, and you see the driveway, and it's all in a very tight spot. I just find it hard to believe that nobody coming and going from that house that night, especially before the big snow piled up, would not see that lump. Sorry, it's the best I could describe what they would have seen in the front yard. I don't understand it.
Did you see my shoe in the snow video?
No, I did not.
John was a size 12 and a half shoe. A friend of mine has a son who's the same height. He's got an old pair of shoes. So I took them and I threw, when it was going to snow out, I threw them outside and I left the video running. And I got time lapse of the shoes. So there's no way Ray Charles can see these shoes.
Hey,
there's no way they miss shoes on the front yard. The yard's not big, one. The lights that they had available to them, two, and the shoe in the snow, there's no way you're missing it. There's no way. The deputy chief who was looking out his windows the whole time, he could see the shoes. Brian, who looked out his windows, he could see the shoes, but they weren't there.
Mary Jo, could Bev, well, as soon as any sentence starts with could Bev, I just say yes. Because she can do anything she wants. Could Bev
Imagine
deny
that.
ACA testimony completely? That would
She
be,
could.
Of course she
That
could.
would blow
Of course.
up. That would be insane.
Of course. And, we're kind of trained to think of these things in the context of appellate issues, which of course only kick in if there is a conviction. So if you just think about it, and if they don't testify, if there are not those experts to say a car never hit Officer John O'Keefe, what happens to the outcome? Yeah, you got a tremendous appellate issue because she's basically reversing herself because she let them testify to some limitation, but they testified in trial number one. I could see her just saying nothing new, just nothing new. I talked to, last night, Linda and I were talking about it, and I said, what if the prosecution never had to deal with that issue, that they accepted what level of testimony there was from the ARCA experts from trial one? That's all that came into trial two. No retention of the experts by the defense team after they were released from the feds. It's clean, it's still very powerful, and it avoids all of this back and forth and the pearl clutching with the judge. What do you think about that?
That whole thing, I mean, they were hired to come and do a job. Karen's team didn't hire them, but the Karen's team was definitely involved. And
at
when
what point, though? And that's what concerns the judge. At what point?
At the end, when they were looking to get paid, because the invoices were then flying. Who's paying for this? Who's paying for that? I'm sure the federal government picked up the tab, right? $500,000, I think they gave them.
Yeah, I don't know. The total.
Half a million, but it's just not. You have experts hired by the FBI sending Karen's team a bill that she's got to pay. So there has to be communication. Like, do I pay? Like, what is this for? I'll cut you a check, but what's it for? I need to know.
And that was the initial inquiry from the court, and then they provided the back and forth of 2 emails, and then proof that it was paid. So now she's all in a bunch because of the 90-some texts that apparently no longer exist, and she thinks they, of course, contain all kinds of nefarious communications. So she wants those experts on the stand, under oath, to explain first contact with the defense, second contact, third contact, up to 96 texts. That's what she wants.
Good thing they got Garino. Garino can find him on the phone, can he? Isn't that what he gets paid to do?
That's right.
Find deleted text messages? I could be wrong, but doesn't that fit in his job description? Could be wrong.
Yeah, well, maybe he can be a dual agent. So we'll see what happens Monday. But that's going to be the layout Monday. They're going to be, these guys
Think about that.
About the contact.
Oh my God.
That's what's going to happen. You know it.
It's scary how little training these guys have. I'm shocked at how little training they have. There you go, Sharon.
Yeah,
I think that's a good point, Sharon.
Yeah, I can't read it as well as you can.
It says, Michael, can they prove that she never went home and had a stiff drink being upset?
Yeah.
Once you're home, you're free.
Of course. And we know she tried to get some rest, but she, based on all of the phone calls and the texts, which were, prosecution says anger building, right? Well, why are you angry after the fact if you killed somebody? Why are you angry after the fact? I mean, every time,
Tom, right?
Every time I kill somebody, I'm as calm.
Yeah, it's just you get ice cream, maybe.
Yeah. Beforehand, though, man, I'm a little jittery. So that's part of that evening's events that the defense can play with. How did you feel when you got home? Did you have another drink? Did you, also, they're going to attack the retrograde extrapolation of, if her blood alcohol was this in the morning, what was it at the time of the incident?
And again, I think that's sketchy. I think how they can't extrapolate how drunk she was at a certain time. They can if it's through, like, I think urine you can do it, but alcohol leaves your system so quick, right?
Well, and
your liver dumps it.
It is pretty well accepted science. You can attack the science, but it is accepted in the reasonable scientific community that they do these retrograde extrapolations. It happens pretty often, but you can have varying opinions on it based on the science. So, Scott McGinnis, Trooper Garino is key in at least 2 cover-ups. He missed 32,000 texts, calls, and emails in the Birchmore case. To protect former cop Matthew Farwell, who's now in federal custody, as we know.
Now we know Farwell's really, really, really tight with Michael Morrissey.
Yeah, and well, look at what he allegedly got away with for years, and apparently some of his buddies, again, allegedly, with this poor girl. Went over to that apartment last time I was here just to, I really think it's important. That's why I'm big on the jury view that's taking place. I'm big on getting your feet in the mix and getting a sense of space and orientation, and went to the apartment where that last video, that lobby video, was taken of both Ms. Birchmore leaving and returning for the last time, and Farwell showing up. We looked at his body language. It's fascinating video. But and that apartment, as you're standing on the street looking at it, immediately to your right is the Stoughton sign. I mean, it is that close to the border of Canton and Stoughton.
Yep. Yeah, it's
and
a
those
shame.
Cops are all commingling.
Yeah, he missed 32,000 texts on purpose. That's
tough to do. What does he think he is, Hillary Clinton?
And again, right? I mean, he can miss them on one device. What about the other device that has the exact copy of it? Because the text has copy on both phones. So if you and I are texting and I delete the text on my phone, you still got yours. Where are those?
So don't try anything, Tom.
Yeah, here we go. Right? Oh my goodness! But again, this is we are absolutely in another dimension here. And I don't know what dimension it is, but it's not a good one.
It's dementia. Speaking of that, apparently from the witnesses we've heard so far, there is something magic going on here in Dedham, Canton, Stoughton, and that is that your memory improves over time here. It is
That's true.
I feel smarter every time I come here. I feel like, man, I got childhood memories that I thought I'd gotten rid of, but they're back and they're vivid. And I just can only credit it to the air or something here.
Your brain works. The electronics, forget it. They don't work. They just chuck anything with power out. It's all in your brain there, and I can't believe that they. And then David Giannetti used it again, and I was just.
Yes, he did.
That's Mona Lisa with one stroke.
They're so smart because that was a gift. That was a gift that was given to the defense that somebody would actually remember better later, further from the events. That's a gift. You never expect anybody to be that stupid. The jury notes that. They pick up on it. So every time you drop that little callback, in the comedy world, they call it the callback. It just cements it in their brains. Like,
I hope he keeps this going all trial. He's got to keep this going. I vote he keeps this going, especially Jen McCabe.
It'll be a theme, I guarantee. Every opportunity is going to happen. Every time there's been some enhancement of recollection, here it comes. No doubt about
it. And I've spoken to him, and I've been in the same room as him, and he is that way. That is who he is. Just amazing.
Well, here's the plan. I think we're gonna bail out here now, and I don't know what I'm gonna do tonight, but I'm gonna do something from somewhere because I'm here. Are these guys looking for you, Tom?
Yeah.
No. Okay. From 6 o'clock, let's do something tonight. Missy, Dizzy, set us up for 6 o'clock somewhere somehow. I might reach out to some other local folks that we've had a chance to talk to in the past. So who knows? I don't know where we're gonna pop up. Trying to think.
Are you local to where you're at now?
Am I local to where I'm at? That sounds like a Massachusetts question, like getting a meal of food. What is?
Yeah, because there's a steakhouse up the street.
I won't tell you which hotel, but it's like 2-3 miles from here. It's not
okay. So yeah, there's a steakhouse. What's the tavern? What's the name of it? Tavern in on the tavern on the green.
Yeah, I don't think it's Tavern on the Green. You can text me that. And maybe
I'm trying to get chat to help me out because it's a real. They have good food. The service though, it's good if you go in small numbers, but if you have a group of people, they just rude about it.
Okay, so if I go as party of one, which is kind of an oxymoron, party of one, maybe I'll be okay.
We also went to the place in Dedham Center, the steakhouse there, right in the corner, right in the, if you walk, yes, if you look down the street that way, there's a steakhouse down there. Tavern in the Square. That's it,
It's a two-alarmer.
There you go. Well,
Couple of large fire trucks going by.
Scotty got it right there. La Ferrano Tavern in the Square has some really good. They got good food. I'll give them that. They have dynamite food, worth buying. But if you go for like a group of 10, 20, 30 people, they're not keen on that.
Linda
they want
said
the
she's
small
buying,
numbers.
so sky's the limit. Okay,
Well, there
bud.
you go.
I appreciate you popping on and helping me fill the space here in front of very
Anytime, my friend. Anytime.
And good luck with your lawsuit.
Yeah, you too. Good luck with your lawsuit.
Thank you. I appreciate that. Okay, buddy. We'll check with you. I don't know. Next time I see you. But,
Yeah, I'll see you. I'm not going anywhere.
Could be tomorrow for all I know.
Never know.
Okay, man. Take care.
Enjoy.
Oh, I just cut him off. I think he was telling me to enjoy the day, and I will. So yeah, we'll do something tonight at 6. That's as committed to what it is that I can get at this point. We'll show up somewhere, do a little this, bring you up to speed on what has happened, what I can snoop around and ferret out between now and 6 o'clock. Got a few hours to do that. I won't be lounging by the pool. So I appreciate you joining. I think we got to most of the questions, and if not, feel free to circle back at 6 with your questions. Oh, look at that. The sun has just gone behind a cloud, and it's great. Okay, we will talk to you soon. I'm Michael Bryant back here in Dedham tonight. In the meantime, try to do the right thing.